On 25th of September, Yoshi was placed to dispose of the injunction application by directing respondents to comply with the. They have not complied with that reason. Yoshi was placed to hear the contempt on 19th of March and 23rd of April was the returnable date. Yoshi kindly let the matter appear due to urgency of the law. That was 19th of April. First, that 15th, and on 19th, your lordship was pleased to hear the matter. Stage is my lord. Lordship kindly sees the order. This is the order, my lord. Lordship kindly sees, my lord. 19th of April, your lordship was pleased to. My lord. Lordship kindly let it appear, my lord, due to urgency of the matter, my lord. Let the matter appear. Urgency is, my lord, lordship was to direct the defendants to effect payment, but they are not effecting payment. They were directed to deposit rupees 80 lakhs to the register audience. They have not doing, my lord. They were directed to file affidavit of profit and loss account. They are not doing, my lord. That's the reason, my lord, they are stopping. My lord. Subject lordship, let it appear on Friday, my lord. The subject lordship, let it appear on Friday, my lord. My lord. Friday, yes. My lord.
We have kind to mention two company applications. Application by the purchaser in respect of a property auction by the court. Wherein they these are applications for paying for a direction upon the official liquidator to execute the deed in their favor upon payment of the balance deficit amount. Total was 15 lakhs, my lord. Five parties, three brothers together, they put in 10 lakhs. Pursuant to order of the court, my lord. There is another party who put in 4 lakhs and another party 1 lakh. The party who has put in 4 lakhs, my lord, he has withdrawn his offer and has taken back the money. So as an application that we'll put in the deficit, whatever, and the deed be executed in our favor. My lord, on auction, my lord. Yes. We have put in the majority amount, my lord. And my lord, the connected applications, there is an order of your lordship, my lord. My lord has pleased to fix those applications on 14th of May. So, my lord, I'm annex the order, my lord. May it be, my lord, may this matter. Yes. By the official liquidators, the same company liquidation, my lord.
Kindly to mention a matter for correction, my lord, very minor correction, the extension of interim order. If your lordship forgives me, we've made the corrections by pencil. The first one, your lordship can disregard, it's irrelevant. That was only for me. That Mr. Dotto was also appearing with me in that with a matter that sounds like Mahabharata. So both got, I think there was a little confusion in the orders with regard to both. I can just hand that over subject to your lordship's approval. I can hand it over to your lordship's officer. They can make these changes. We had served on defense number 1, 2, 3. Mr. Dhruvo Ghosh. Correct, very well. I should.
May I have your lordship mention one matter? You see, in this matter, pursuant to your lordship's order, court fees has been deposited. Court fees has been deposited. There was the order. But the person who was conducting the deposit, in the name of the plaintiffs, he has mentioned and in the name of the defendant. That is to be accepted, your lordship. I am to. How the defendant's name, the court can be accepted? How the defendant's name, the court can be accepted in the name of the defendant? Court fees has been deposited by the plaintiff, and there is the phone number. Mobile number is of the clerks of the advocate, plaintiff's advocate. What is the wrong here? The name which has been mentioned here, that is the name of the defendant. Premanand Jaiswal. It would be Pawan Kumar Kajaria, plaintiff's name. By mistake. The person conducting the online payment, he has done this mistake. Then it is 18,000. My lord, then 15 days time may be permitted.
Lordship, may
May Lordship's kind leave to mention, Your Lordship, I'm praying for a leave to file an application without a Your Lordship full cause title. Matter has been, Your Lordship, transferred to the undefended list. Your Lordship, I am the defendant. Plaint, copy of the plaint has not been served upon me. So I don't know, Your Lordship, the exact cause title. That's why, Your Lordship, I'm praying for a leave. Not served. That's the point we have taken, Your Lordship. No, when the matter actually appeared, from the cause title we came to know and we appeared before the Honorable Court and we expressed that the writ of summons has not been served. But as per the report, Your Lordship directed the matter to be appeared under the heading undefended suit. That's why, Your Lordship, we have taken out an application. But Your Lordship, the cause title we don't have because we don't have the copy of the plaint. That's why, Your Lordship, I'm praying for a leave to file the application with Sharma and Kajaria, Your Lordship. I'll serve the copy and then, Your Lordship. I'm grateful, Your Lordship.
May I have my lord's kind leave to mention execution application for inclusion, my lord. First time it's going to appear tomorrow.
Lordship, may
Commercial.
My lords, may I have your lordship's kind leave to mention a matter, your lordship. This is in respect of a commercial suit which was undefended, your lordship, and our witness action was concluded on 26th of July 2024, your lordship. And in the meantime, the defendant lordship preferred an application for filing their written statement, your lordship, which was your lordship was pleased to dismiss it, your lordship. After that, your lordship agreed by your lordship's order, they preferred an appeal, your lordship, and by the order of the appeal, the only order was that it was set aside only to enable the honorable court to decide the service of the summon upon the defendant after recording evidences. The deputy sheriff has submitted its report which reflects the service of the summon upon the defendant, and the matter was kept for argument on 17th February 2025, your lordship. The matter is running, your lordship, in the list today. This court, lordship. Lordship. Lordship, that it was... That has been done, your lordship. Lordship, the court was, your lordship, it was directed by the appellate court that the your lordship has to decide the service of the summon. It has been decided by the summon of the, that it has been served upon them, your lordship.
Examination in terms of the appeal court order has not yet taken place. At that stage, the matter is still appealing.
Only to the, your lordship, kindly see, it has to be set aside.
Now to examine the
Your lordship, the order is there, lordship, in my mentioning notice, your lordship. Kindly see the order. Page 2. In view of the aforesaid direction, the impugn order is set aside. However, we make it clear that the reason for setting aside of the impugn order is only to enable the court to decide the service of summons upon the defendant after recording evidence.
court has to not take the evidence of the bailiff who had
Your lordship, the sheriff has, lordship, the learned sheriff has submitted their report, your lordship. The report is there, your lordship.
We have received the copy from the
We have received the copy from the court itself.
copy to हम लोग को
court has given the copy.
हम लोग court से
यहाँ पे दिखाओ. ये order दिखाई last.
The order is, your lordship, on lordship.
Yes.
Lordship.
मतलब we
ये
don't
last
have
order.
this.
Kindly order dated January 24, 2025, your lordship. In my mentioning notice, let the report be supplied to the learned counsel for the parties in the course of the day. Let the matter appear on 17 February 2025.
This court has given me the copy.
We have got this report, your lordship, from the court itself, honorable court itself.
From this court. The deputy sheriff has submitted.
Lordship,
The deputy sheriff.
the deputy sheriff of Calcutta has submitted the report, your lordship. It is recorded in the order,
Examination has to be taken.
January 24, 2025.
Now the last part of the appeal court order.
Lordship, undefended commercial suit, your lordship.
Today 98 number. Serial number.
Today it is, your lordship, in the list, item number 98. I am humbly beseeching your lordship if it can be kept in before the vacation, your lordship, at
Any date.
any date, your lordship's convenient. Your lordship, for this evidence.
It is running for the arguments. On the arguments.
Lordship, so the argument, lordship, already the report has been submitted.
Vision bench order.
The report is to be again the same report as submitted by the MDSRE. Court has to examine whether they have taken the address which is mentioned in the gate, that is not
Oh,
there.
they remember that.
No, lordship remembers everything. Lordship has given a very elaborate order, that is why lordship remembers.
Other gate is there, but it has been solved.
Kindly see the last page of
Your lordship, kindly see the last page of the
that report.
that report. That report.
Time, my lord.
Oblige, your lordship. Obliged, deeply obliged.
May I be permitted to mention what she
No, a correction of an order, my lord. May I just hand up the copy, my lord. My lord, paragraph 16, my lord, the bracketed portion, my lord, the same was filed. It has not been filed on 16th of November, my lord. That is the case, my lord. That was the 128th day. They missed the bus. So, my lord, the right was forfeited, my lord. This,
the dependent number 5, my lord.
this
If
matter can
the
just.
state of this thing, my lord, it should be my application for acceptance of the written statement, my lord.
Yes, ma'am, that can also can be done. Can be kept to be mentioned, my lord. This correction can be done. No, my lord, they did not file it on 16th, my lord. No, that is the case. I have got a report from the department, my lord. My lord, I got a report. No, I got a report from the department, my lord. It was there.
Yes, sir. Department giving some report, department having 3 branches. And when the court examines the report on something else.
No, that is.
That day it was found that before your this written statement was refused, before that the written statement was on record.
No,
That's why it got
no, they had. Can be taken up tomorrow, my lord. Tomorrow to be mentioned.
My lord,
Yes, my lord.
may I be permitted to mention, my lord, item 73, my lord, it's a witness action. My lord, my witness was in the box, was being cross-examined by the defendant. My lord, last on 10th February, the matter was directed to appear on 7th March, my lord. Thereafter, my lord, I believe, my lord, they are giving suggestions. One day they were perhaps, my lord, one day perhaps the examination, yes, cross-examination, my lord. It's not appearing. It was directed to appear on 7th March. Now it is in your lordship's list. It's item 73. Item 73, my lord. Yes, my lord. It can be, if a date can be fixed, my lord. My lord, then it will be, when in July it will be taken up, my lord. That's, my lord,
I'm for the response.
I am given notice. I believe one day they will finish, my lord. That's what, cross-examination of the plaintiff's witness. No. Then they will adduce evidence, my lord. My suit is, that's why. Yes, my lord, 73. Yes, members fine. Fifteen. Grateful, my lord.
Lordship, may I be permitted to mention one matter?
আমি
Lordship, it's a commercial. Lordship, I'm just taking the need to file my digital.
মামলাটা তো হয়েছে নামটা দিয়ে দিন।
No, Lordship, I have not taken the leave. That is what I am seeking right now, Lordship. The leave of this in October 2024, 24, last year.
My lord,
Lordship, 1 week's time.
my lord, may I be allowed to mention one, my lord, matter? Item number 100, my lord. Lord, this has 100, my lord, of today's list, my lord. This has been, my lord, substantially heard by, my lord, Justice Pattanaik, my lord. My lord, the defendant has completed its arguments. My lord, the defendant had completed its arguments. My lord, the plaintiff has also commenced its arguments. My lord, the matter may be released to be, my lord, assigned before Pattanaik, my lord, Justice Pattanaik, my lord. No, my lord, not part heard, my lord. Grateful.
Mention a matter, other than seeking this court to file the requisites measure and to obtain a certified copy of your lord's order. My lord, 11 July 2024. My lord.
Mention item number 1.
Well, in this matter, I am for the defendant.
Lord, it's my suit, your lordship. I was called to tell you, your lordship. My lord, there is some, your lordship, miscommunication in this matter.
Your lordship. Your lordship, am I audible? Your lordship's mic is mute. We cannot hear anything.
Will be doing it by so we are also under the He's the
Lakshmi, I'm for defense number one, in this matter.
well, 8 volumes. Great. Yes, we have served. Well, can I file the affidavit in court also? Evidence. Then it will come in the records of the court. May. Thirtieth June.
4 weeks will take us to May.
There's only one thing. Your Lordship kindly request, that's a humble request, since my learned senior friend has expressed today only, one day before the commissioner, that they will only do it by affidavit in chief. Your Lordship will kindly record that I will be entitled to pray for. Correct.
He
Your Lordship
still
only
got the
record
whole
that we
night
entitled
he
to pray
has.
for time.
Well, he can stay awake the whole night and read everything.
Let it be understood that I will. Grateful.
But make sure on
Yes, yes. Obviously, yes, yes, no doubt.
Let him ask 2-3 formal questions.
Yes,
at
yes,
least,
formal
then
questions I will ask. Yes, yes.
Witness will come.
Yes.
Yes, thanks.
Nothing. Nothing. But here again the commissioners, the date is over. They have not. I was not in the commission, but I'm told that it has to be extended. The cross-examination is continuing. Today.
Today is going to. My lord, in May, I have some personal difficulties. So you can't, Lordship.
15th July for the is going on. My learned friends can say how long they'll take.
My lord, the difficulty is that the witness has
Witness
been
lost his brother, I'm told. So he's not been coming.
smart.
কিছু
Yes, my lord. My lord, there is an from March 2020 till February 2020 the limitation on any grounds, my lord. The suo moto order.
The second application in the suit of the same nature. But Lordship had earlier passed an order, but in my favor, with suit for recovery of money lent in advance. But I had filed an application for injunction on the bank accounts of the defendants, and but considering that, Lordship has passed an order but on 10th September 2024, but restraining the defendants from dealing with the bank account which was specified in that application, and restrain them from transferring or creating any third-party rights in respect of some immovable property, which your Lordship will find at page 49 of my application, the second last page. Now, my lord, after this order, my lord, we have found out various other accounts, bank accounts of the defendants. Now, my lord, the apprehension is, my lord, the bank account which I knew about does not have any funds. But now that we have discovered 3 or 4 more bank accounts, I'm sorry, 7 more bank accounts, well, they also ought to be restrained from dealing with that part of the money from these bank accounts.
Lordship, I appear on behalf of defendant
Yes,
number
there is also an immovable asset as well, which we have discovered in paragraph 12. Lordship will kindly see page 6 and 7 of my application.
I appear on behalf of the defendant numbers 1, 2, 3. Lordship, I seek an opportunity to file an affidavit in opposition to show that your Lordship, the injunction order already granted covers the amount. Your Lordship, because this also includes an immovable property which is way more than the injunction that has been granted. So, your Lordship, if I am able to satisfy your Lordship that the injunction already granted is sufficient, your Lordship, I do not think the rest of the bank accounts need to be attached. If your Lordship allows me.
In that, yes, they can file an affidavit. In the defendant number 4 has been struck out from that. But kindly takes my prayers. But
Defendant, they are made party.
नहीं अपनी नहीं. But kindly takes page 13. Prayer E. Let them file an affidavit, also an affidavit disclosing the full and further particulars of the immovable and movable assets. All their bank accounts, whatever balance lying there, if I'm already secured, I'll not pray for anything more.
I'll just disclose that your Lordship's injunction order already granted.
No, let them disclose the balance lying in the bank accounts. Yes.
Lordship, I've seen prayer E. Lordship, if it is required, because your Lordship's injunction already. Very well, Lordship. Very well. Very well, Lordship.
Yes, automatically, I'll be protected.
Lordship, subject to correction, Your Lordship, it was my humble prayer because that immovable property in itself is sufficient to cover, and I'll disclose that. Very well, yes, Your Lordship. I'll disclose the valuation report
as just so that they are not permitted to circumvent the order.
No, I'll give it to
bank account which I had specified in the last application. Let them disclose the balance lying as on this date.
I think because they have made a party.
That means there is nothing. No,
Lordship, interim order after
affidavits.
One client one client is asking for a figure which my client cannot have. Lordship, kindly grants me 3 weeks because the defendants.
And also the balance lying at the bank account, which I specified in the previous application.
Lord, just one indulgence.
Specified in the order dated 10
Specified
September,
order dated
10 September 2024.
Yes. Well, in that case, there is a sufficient balance. I'll pray for one of this application, whatever.
Lord, I appear for defend number 3, my lord.
You're not there.
But this application has been served upon me, my lord. That is why I wanted to bring to my lord's notice. I have been removed, but this application has been served.
Grateful, lordship.
After vacation.
Very well, lordship.
Extremely grateful, lord. Extremely grateful.
Number 17.
Lordship, same order in item 17 as well, lordship.
Yes, sorry.
I'm sorry, Manoj, same order.
Extremely grateful, lord. Extremely grateful.
Item number 18.
So by item 18, I am
Suit under order 37, my lord, to which they had filed a leave to defend affidavits are complete, my lord. On the other day, my lord, they had commenced their submission, my lord, on this. My lord. Claim on account of recovery of financial assistance rendered by the plaintiff.
lordship, order 37 suit, my application only so that no summary suit is, no summary degree is passed, can be passed. Your lordship, it's a tribal issue. Lordship, I've taken 4 points precisely: that there is no cause of action since there is no default. B, it is barred by limitation. C, there are misjoinder of parties. And D, that the documents that they have relied upon, the pleading and the documents relied upon are different. That I'll show from their application itself. And TDS is not an acknowledgement of debt. Lordship, may kindly takes up my application GA2, lordship. Lordship. If your lordship kindly takes up their application as well side by side, just to show your lordship, that should be your lordship, the suit, in fact, the suit itself. Your lordship takes lordship. 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 Lordship kindly sees the cost title. There are two defendants, Skipper Furnishing Private Limited and Kamlesh Agarwal. Lordship, there is no agreement or contract with the defendant number 2 at all. If your lordship sees the annexures C and D of the plaint, your lordship, page number, your lordship, 37. This is their net worth certificate. And now your lordship kindly turns over to page to annexure D at page 38. Your lordship, annexure C. Annexure C has been issued by one of the a CA of the plaintiff company to show that they have not lent more than their trade receivables. Lordship, since it's an NBFC, there's a regulation that they cannot lend more than their receivables or something like that, for which they have issued this net worth certificate. Now kindly takes page 38, your lordship. The entire sum of rupees 30 lakhs that they have advanced at page 38, that your lordship will find net worth certificate to show that they have not did not exceed 60% of their paid up share capital. Lordship, that is for the plaintiff to show. Lordship, I am more concerned about page 30. Anuban Finance, that is the plaintiff. Yes, your lordship. Now, if your lordship, the corresponding pleading, your lordship will find at paragraph 5 of their application, of their suit, your lordship will understand that since it's an NBFC, they could not have paid more than 60% of their paid up share capital. That's why they have annexed this certificate. Now, your lordship kindly takes up page 38. The letter from the plaintiff to the defendant number 1. If your lordship sees, this date is 3rd of June 2014, and your lordship will see it is addressed only to Skipper Furnishing Private Limited. That is the defendant number 1. Defendant number 2 has not been given any accommodation, any loan. And your lordship will see the transaction also referred to being RTGS is of 38 lakhs drawn from such and such, and this has been transferred to the defendant number 1. There is no transaction whatsoever with the defendant number 2. So, your lordship, my first submission would be, even the contract as alleged by the plaintiff is only with the defendant number 1. The defendant number 2 is a director of the defendant number 1, but there is no there are two separate legal entities, and the defendant number 2 cannot be dragged into this matter because they have transferred it to a company, and the company is liable to pay back. There is no privity of contract with the defendant number 2. So, your lordship, my first submission would be no decree can be passed against the defendant number 2. In fact, it's a misjoinder of parties, and the defendant number 2 ought to be deleted from the array of parties. Therefore, no decree or summary or otherwise against the defendant number 2 can be passed. Lordship, allegation in the plaint is that the company was represented by the defendant number 2. But your lordship, a company being a legal entity, juristic entity, has to be represented by some of its personnel. So the defendant number 2 would have represented the defendant number 1, but that does not make the defendant number 1 liable to pay the sum which is to be paid by the defendant number 1. And the money has also been received by the defendant number 1. The defendant number 2 has not received the money. So defendant number 2 is not a party to the contract, has no privity of contract, and therefore cannot be liable for any sum. Lordship, kindly takes up paragraph 8. Lordship, so that is their allegation. Good, bad, indifference, it's a separate juristic entity, legal entity, and it's a company. So if they have given a loan to a company, the company is liable to pay back. Now, your lordship kindly sees, and on this basis, they have made the defendant number 2 a party. Your lordship kindly sees paragraph 8 onwards, they have only referred to, however, the defendant. It's not in plural. It's only in singular. Lordship, in my copy,
4 kindly see.
In hand. Lordship, that is not there in my copy, maybe.
Put it down again. What is this? In scrutiny, it is duly corrected, mal, but I must. Well, I think, well, yes, my right.
And your lordship, I believe I will have to go through because the plaint that I have been is supposedly differing from the plaint that your lordship has.
And thereafter, yes. Service korbe.
The plaintiff has taken steps under 12A of the Commercial Codes Act 2000, no section, your lordship. Then the service becomes defective.
No, no, Judge Sahib, after lordship says, you will say. But after 37, so after lordship says, then you will do the needful. But those malad, page 11 malad. Which I verify.
I verily believe to be, the last line is, I verily believe to be true and
But
correct,
I
and
think
those contained in paragraph such and such, therefore are my humble submission to this honorable court.
That is there, my lord. No, that is there.
No, Lordship, may I hand over the copy so that your Lordship can will be able to.
This is the replica what my learned friend has, and I do have, my lord, are the replica, my lord.
The very
In any event, my lord, I'm
After the verification for the 1, 2, 3, 4, 5, 6, 7 line, which word start which?
yes, my lord, which I
To which it is added, you added the track pen along with the cost item.
my lord, to avoid, my lord, all this, my lord, let me give a fresh copy. Fresh, yes, my lord. And my lord, kindly keep it the next week, my lord. Tomorrow, no. Let them be given some
Lordship, I
time to
have
think of it.
Lordship, subject to what falls from your Lordship, I have some doubt in my mind that since the plaint in itself is services being affected.
Now, yes, he has got one fault from me. It's a long dragging matter, my lord. It was already. But the copy has not been served. नहीं उधर का within a course of the day, my lord. Kindly keep it next week, my lord. Next week, rakho. This matter was fixed on the earlier occasion. Unfortunately, my lord. 14, my lord. My lord, like the earlier occasion, may it be fixed, my lord. The time be fixed, my lord. It was already fixed. Kindly, my lord, kindly see the last order.
Lordship.
The order on the record. It is 3 p.m. fixed.
I'm being led by Mr. Mukherjee. Lordship, he's just pointed out, he's just here.
On that day.
Very, Lordship. Your Lordship, but it,
my lord,
No, my lord,
everything is there, my lord.
they are serving again, your Lordship. That's
Order
not an issue.
37, Rule 2, Sub Rule 2 says, my lord, the summons to the suit shall be in form number 4 in Appendix B.
That are all.
Have received the summons, but with a plaint which is not before my lord, so it's a different plaint.
Yeah.
The plaint will be served. Will it be served as per the under Sub Rule 2, my lord? It has to be accompanied by the summons in form number 4 because the early.
My lord, technicality should not.
I don't want to stand in the way.
Stand in the
I don't want it to be defective. So that's why I was just saying that the summons of the suit shall be in form number 4 in Appendix B or in such other form as from time to time be prescribed. I will receive the summons with the plaint. Then I have to take steps, enter appearance, file an application for leave to.
They have categorically admitted that they have
of a plaint
received the summon,
which was defective, which is not what was said before my lord. So now that when we are serving the plaint, will it be accompanied through the summons? I'm just asking this question to myself.
I am asking this question. Order 37. Can this hyper technical argue?
Order 37 is very technical.
Yes, my lord. Wherever there is, allow me to say, my lord, where is there are technicalities? The statute has been specific, loud and clear. These are the technicalities that you have to follow.
Unless and until the rectification is not being made, you cannot lodge the
I humbly bow down and appreciate.
Department see the correct break has to be served to the defendant.
I bow down and appreciate, but my lord, here, my lordship can also understand the technicalities are being pointed out just for restraining the court to go into the merits. Let them come. And my lord, kindly see my lord's last order, my lord. It was already fixed. Unfortunately, that day the court didn't sit. At 12 noon, my lord, like 14. My lord, may a time be fixed. Kindly, my lord, kindly see the last order, my lord. My lord, the court, unfortunately, the court didn't sit. That's why, my lord, the hearing could not take place. My lord, can you see the order, my lord? No.
Court will not have done any matter of the resolution of the past.
My lord, lordship believes that I am on that, my lord. No. No, my lord, kindly, please. No, I am leaving it to your lordship, my lord. I shouldn't say anything. We'll come back at 15th, my lord.
Item number 19, Your Lordship, I appear for the defendant.
Only one thing, may the matter retain its position. No, retain its position, my lord.
This was my application for extension of time to file my written statement. It is within 120 days. On the last occasion, Your Lordship had called for a report from the department. Lordship, the suit was filed on 23rd September 2024. The writ of summons was the effectuated service on me on 21st November 2024. It was made returnable on the 6th of December 2024. Your Lordship, I am within the period of 120 days. I filed it on 12th March 2025. 12th March 2025, Your Lordship. Writ of summons I received on 21st November 2024, Your Lordship. 21st November, the 30 day I had received it. Yes, Your Lordship. 12th of March, Your Lordship. It was affirmed on 27th February 2000.
That is one time, no doubt. But that it took the what is the proceeding that from time to time they are dealing with within 30 days was there the first commercial court made out. But no, but they have sent the draft only to gain the time, and the last moment they have come before Lordship. So that I leave upon your Lordship, my lord. No. But this is the objection. Definitely, this must have to come earlier, my lord.
Certain genuine embargoes. Defendant number 1, 2, 4, and 5.
I pray before the substitute service before Lordship. No, I am asking this. Report is here, my lord. Yes, my lord. No.
5, Your Lordship, I am appearing. Yes. Lordship.
They are the all the partner are there, my lord. Each one all the 4 partner are there. 3.
3, Your Lordship, I don't have instructions anyway, Your Lordship.
The partner, my lord.
Maybe a partner, Your Lordship, no instructions from 3 because this will be in their personal capacities as partner.
Same address, everything is same, my lord.
It's a limited liability partnership, Your Lordship, not a regular partnership firm. So separate liability has to be ascertained upon. One year. 27th of February, Your Lordship. I'll just 27th of February. Made ready on 24th. With the
28th.
sir.
28th. 28th.
Your Lordship, I apologize. Just one incongruity on my part. It was affirmed on 28th of February, not 27th. I apologize. The boys, sir. How old are they? Yeah. What?
Yes, my lord. Purulia, my lord. Purulia, that's Bengal. Yes, my
Bengali
lord.
probably, but the different.
Hindi, there a person in the or the person are Hindi speaking, my lord. Yes, my lord. Yes, my lord. Maybe teach times of India, my lord. English. Hindi, I that make it Ujala, my lord. Ujala. Then Sanmark. My lord, there are three paper, only two paper, either one.
Cost of India, but to consider one.
To come up. 2,500 crore.
Lordship, at the risk of being reprimanded, just one there, if I may make shouldn't comments to your Lordship, I will not press for it. Lordship, the aspect of cost, your Lordship, 5,000 rupees. Lordship knows these are not the fault of the defendants, the advocate's fault, your Lordship. I'm taking it on myself. Lordship will kindly, Purulia, your Lordship knows this, West Bengal, Purulia, Lordship, 5,000 rupees. I will not press for it, your Lordship. Grateful, extremely grateful.
20, my lord, I am appearing on behalf of the plaintiff. My lord, pursuant to your lordship direction passed on March 25, 2025, my lord, a further remuneration of 25,000 has already been paid to the learned receiver, my lord. And my lord, interim order is expiring today, my lord. I am praying for extension of that interim order, my lord. And my lord, and my lord, report, my lord. My lord, it appears from the report that the postal receipt returned with unclaimed, my lord. And my lord, I am praying that unclaimed is a good service supported by a judgment of my lord, Honorable Supreme Court. Only one defendant, my lord. And my lord, that is the personal service, my lord. And my lord, that is by the my lord sheriff office, my lord.
You examine the postal authority or sheriff, I will give them. If you wanted to rely upon this report, you either examine the deputy sheriff or the postal authority, it is served. It is unclaimed by them. How it has been unclaimed. Because the court is burdened with all applications, the service is not affected. It is not correct report.
But my lord, it is one crooked lane, just.
No, that's why I know the judgment. This is the I have a reported judgment. Unclaimed is a good service. But anyhow, again the application is coming before this court. Today morning I also got one order from the appellate court that the sheriff is to be examined or the process server is to be examined. So I have to go with the division bench direction. What can be done?
That is my lord too.
If you're telling that you will examine that, I will be the pick the date to examine the postal authority. Because this report, where is the connected document? Unclaimed, where is the connected document?
My lord, they have only just supply us that only report, my lord. Only report. My lord.
Where is that? Where they are keeping?
My lord, it is reported, my lord, one duplicate copy of the writ of summons along with copy of plain. My GH2 is my lord 2.
If the print is in scrutiny by the how the written summon is served, issued.
After the scrutiny, my lord, someone is lodged to the sheriff, my lord, and they went to the sub, my lord. And
correct. Whatever the suit is the
my lord.
If it is the written answer,
That document to be produced before this court, my lord. My lord. My lord, kindly adjourn it, my lord. And my lord, entry order may be extended, my lord.
where it reveals that if the page of this page has tried to solve the copy of the record of the but it was found that the main role of the department of law
My lord, specific time is there, my lord.
the service that the data someone was served in the postal service on 25 but untenable packet of return answer with the remark I think on 28th of March. For the printing submitted. Also for the plaintiff and relied upon judgments in the case of in the case of Priyanka Kumari versus Sailendra Kumar in asset transfer. Unclaimed. Unclaimed is the service. Use the report have been reported. But so find that the record of the suit and the is unacceptable. According to the department director to place the record of CS count 819 of the along with all documents written unserved written unserved written of summons and this matter on
Entry matter may be extended, my lord. Much only.
Number 21.
Lord, I appear for the plaintiff, my lord. This is the matter where ex-employees and ex-party injunction was granted by your lordship, my lord, extended from time to time. It was till the 25th of this month, my lord. We had gone before the urgent determination court, my lord, and that has been extended till 30th of April. The defendant is not appearing in the suit yet, my lord. If your lordship can extend it now, my lord, I'm not asking for confirming the interim order at this stage because there were some amendments which had to. Notice has been served. Amendments are to be carried out. We had filed an application for amendment. Your lordship had allowed it. Whether the amendments have been carried out and completed, my lord, we don't have instructions, my lord. Kindly extend the interim order for some time, my lord. And after, it is till 30th April now. My lord. Deeply. My lord, I am for the plaintiff.
My lord, I am for the defendant. My lord, it's my application, my lord. My lord, they have already served a copy of the affidavit in opposition upon me, my lord. My lord, I have affirmed the affidavit in reply, my lord, but I have not yet served upon them, my lord. I am serving them, my lord, now and then. I'll let it appear on the next day, my lord. Next week, my lord.
My lord, this is an application. This is an application filed by them seeking amendment of the written statement come counterclaim. My lord, we have filed our opposition.
But I have not served the reply upon them, my lord. I am serving it now, my lord.
Lord, I'll be filing the opposition now.
But let me file my reply.
GA3. ठीक था दो तो yes Lord, I am for the plaintiff. Lord, this is
I appear on behalf of the defendant in this matter, ADM Agro. My lord, I'm being led by who couldn't be present today because of a personal exigency. I seek a small, short accommodation, my lord.
For what?
For a next date, my lord.
Affidavit in opposition?
My lord, yes. The
My lord, served
affidavit.
on the accept-
There are two applications, my lord, GA3 and GA4 taken out by the defendant. One is seeking rejection of the plaint, one is for revocation of clause 12 leave.
12A.
Separate application.
And one is rejected.
Clause 12 and
711.
clause 12 and 711 read together.
Both separate. And both affidavit you filed.
Both affidavits.
You are filing reply.
Yes, we are filing the
Yes,
reply.
my lord, the reply. My counsel is there to file the reply. My lord.
Census suffering for the plaintiff, census suffering for the defendant. Plaintiff has filed affidavit in opposition in connection with GA Com 3 of 2025 and GA Com 4 of 2025 after serving the copy to the land counsel for the defendant. Defendant has filed affidavit in reply of both the opposition after serving the copy of the same to the land counsel for the plaintiff. Let the same be kept with the record. As the pleadings have been completed, list the matter for hearing on last one 17 रखा था ना 18 June.
Deeply.
My lord, can I please request for the matter to be fixed at a time? It's a one hearing matter, my lord.
If you want time, madam, then it will go to the July second week. If you're ready, I will give the date.
My lord, we have,
Time. If you find the time.
my lord,
Then
we are
before-
fine with you. We're fine with you.
Before that, there is no, you will not get the time.
Much obliged, my lord. 18 June it is.
Deeply obliged.
Deeply obliged.
My lord, as per the appeal court's direction, they were directed to submit the rest of
Paid the interest.
My lord,
Paid the interest.
in the meantime, the matter came up before the appeal court, and the appeal court directed the defendant number 1 to put in the rest of the amount. My lord, they have been given 3 weeks' time. My lord, Lordship will adjourn this matter till then.
Lordship, I appear for the defendant number 2.
I appear for defendant number 1. We have already deposited 34 lakhs additional as per by our application that was made before
I
the.
am adjourning till June.
Yes.
15th, then the court is there.
Very well, Your Lordship.
Obliged, Your Lordship.
So suffering for the decree holder. So suffering for the judgment debtor number 1.
I appear for judgment debtor 1, Your Lordship.
Judgment debtor number 1 and so suffering for the judgment debtor number 2. In view of the order passed by the appellate court dated 24th April 2025, the case is adjourned. Let the matter appear on 12th June.
Obliged, Your Lordship.
The order passed by the order dated 24th April 2025 passed by the appellate court be kept with the record.
So grateful, Your Lordship.
Very grateful.
Next.
Please, my lords.
25 Lordship, I appear for the plaintiff petitioner.
My lords, I am appearing.
Yes.
It was for the defendants to start their reply.
Please, my lords. So, my lords, I would request my lords to refer to the order passed by this honorable court itself, my lords itself, on 27/9/2024. Because a re-argument has been led on the aspect of Kapil Wadhwa and other Philip
Yes.
Morris. But as far as my lords has already concluded that particular aspect, whether this falls within the parameter of infringement or not.
Yeah.
My lords, I request my lords to come to my lords 17, paragraph 17.
Yes.
Because prior to this, my lords has already considered in paragraph 14 what is infringement. I'm so sorry, my lords. Paragraph 14, my lords has considered what exactly is the infringement.
Yes.
Whereas then, my lords, 15 subclause. I'm reading paragraph 15. Subclause A of subsection 3 of section 30 of the Trademarks Act deals with situation where the registered proprietor of a trademark sells the goods bearing the trademark to a person and thereafter assign the registered trademark to another person. The said another person cannot oppose further dealings in those goods by the person who has acquired those goods bearing the trademark. The subclause operates in a well-defined territory of its own. The situation contemplated by subsection 2, subclause B, is the goods having been put in the market under the registered trademark by the proprietor or with his consent,
as lawfully acquired by a person and further selling of the goods in the market. It is here where the issue of lawful acquisition of the goods when put in the market and further sold in the market arises for consideration. And whatever be the view taken, the market contemplated being international market or the domestic market, my lords. My lords, then in paragraph 17, my lords, take case of Kapil Wadhwa. In case of Kapil Wadhwa, the division bench of Delhi High Court held that subsection 4 of section 30 of the Trademarks Act, it would be relevant to note that the further dealings in the goods placed in the market under the trademark can be opposed where the legitimate reason exists to oppose further dealing, and in particular where the condition of the goods has been changed or impaired. This is one of the argument where allegation has been made that I have not denied. I'll show my lords from the affidavit. With respect to the physical condition being changed or impaired, even in the absence of statutory provision, the registered proprietor of a trademark would have a right to oppose further dealings in those goods in as much as they would be the same goods improperly so called, or to put it differently, if a physical condition of the goods is changed, it would no longer be the same goods. But subsection 4 of section 30 is not restricted to only when the conditions of the goods have been changed or impaired after they have been put in the market. The section embraces all legitimate reason to oppose further dealings in the genuine legitimate reason, which where genus embraces other species as well. In the present case, now my lords, here, in the present case, admittedly the plaintiff is having a registered trademark SRMB, Wingrip and X-Ribs. It is also admitted that the defendants are also selling the goods having the said mark after purchasing the goods from the dealers of the plaintiff. It is not a case of the plaintiff that defendants are selling its goods by making any changes or impairments of the goods. The defendant has supplied the documents to the plaintiff to establish the defendants has purchased the materials from the dealer of the plaintiff, namely Mishra Steel. The plaintiff says that the plaintiff has given a dealership of the said goods to the of the plaintiff having trademark SRMB, Wingrip and X-Ribs to Mishra Steel is restricted to Muzaffarpur, but the defendants are selling the goods per product at Islampur. The plaintiff said that the dealer should not encroach other dealers or distributors' territory as the company policy, but in the present case, the defendants are selling the goods in the different area than the Muzaffarpur after purchasing the material from Mishra Steel. And the plaintiff also says that evil by the defendant are in connivance and colluded with Mishra Steel. Considering the above, this court finds that the Mishra Steel is a distributor or dealer of the plaintiff, and the defendants have purchased the material from the dealers, and the plaintiff are selling the same in the market without any changes and impairment. As regard whether the defendants are entitled to sell the products at Islampur or eBay bills relied by the defendants are in connivance or colluded with the dealer of the plaintiff can be decided only after exchange of the affidavits. In view of the court find prima facie case not been made, balance of convenience in favor of the plaintiff at this stage. Accordingly, ad interim injunction as paid by the plaintiff is refused. So, my lords, this was the observation made by this honorable court, my lords. After this observation, we filed an affidavit.
Yes.
My lords may have the affidavit which we have filed. If my lords have the reply which we have filed.
Reply or affidavit? Your affidavit?
Reply affidavit, my lords.
Yes.
My lords, I'll just come to paragraph 14 at page 9, my lords.
14 at page
9. My lord, this is dated. I'll just tell. 6th of 2024, my lords. Affidavit in opposition on behalf of the defendant.
affidavit in opposition affirmed by Mahesh Agarwal.
Please,
So page 14, paragraph 9. It is
paragraph 14, page 9, my lords.
Achha.
I'm so sorry.
Yes.
So, my lords, here I gave the description of all the goods, the defendants crave leave of this honorable court to place on record the invoices along with the allied supporting documents such as bill T, consignment note, EB bills, screenshots from GST portal of the defendants evidencing taxable inward supplies received from the registered person B2B from the quarterly GSTR 2A through the defendants have purchased the goods. The particulars, my lords, I have annexed all the invoices through which I have purchased the goods from Mr. Steel. My lords, this is tabulated and it is a part of my lords. I'll take my lords to that also. My lords, then paragraph 15, I'll just read three paragraphs, my lords. Paragraph 15, it is evident from this document that the goods were purchased from the dealer, namely Mishra Steel and BK Associates. A reference is made to the supplementary affidavit filed by the plaintiff, specifically to paragraph 5, where the plaintiff admits that the Mishra Steel is one of the authorized dealers. However, relying upon the agreement between the parties, the plaintiff alleges the Mishra Steel could not have sold the product to respondent as they were barred under the agreement from selling outside the designated territory. Despite this, there is a categorical admission that Mishra Steel is an authorized dealer. My lords may have page 13, that is paragraph 21.
Yes.
The defendant emphasized that their activities oblique practice fall within the legal protection provided under the provision of Section 33 of the Trademarks Act, which permits the resale of lawful acquired goods in their original condition. Defendant has merely resold the plaintiff's own goods, to which the plaintiff has already earned profit, and their trademark rights stands exhausted. The said goods are being sold without any change or impairment in the impugned goods and without an attempt to mislead or deceive the consumers. The plaintiff assertion of infringement through confusion or deception is legally unfounded. So, my lords, I have specifically stated, I have put on record the documents by virtue of which I have acquired the goods. I have put on record, I have given an affidavit that the goods which are being sold are impaired. My lords has already given a finding. My lords, this is further substantiated by the fact that the dealership has not been terminated, and that termination happened on 9/10/2024, which they have filed along with the rejoinder. My lords, the plaintiff has filed a rejoinder to this affidavit, my lords.
Supplement?
Rejoinder affidavit filed by the plaintiff.
Yes.
My lords, this is shown by Mr. Satyajit Adhikari. My lords, I'll straight away come to Annexus C, that is page 23.
Yes.
My lords, this is date becomes relevant. This was sent on 9/10/2024 after the orders are being passed, my lords.
Yes.
Paragraph 3, page 24. However, it has come to our knowledge that you have engaged in an, my lords, has it? Paragraph
Yes,
3.
yes. Yes, yes, yes.
However, it has come to our knowledge that you have engaged in an anti-competitive conduct and acted in fundamental and repudiatory breach of the said agreement with a malified and incomplete bad faith, engaging in an illegal sale of SRMB products to third parties beyond the geographical territory of Muzaffarpur without any authorization or permission from SRMB, preparing and submitting false and fabricated invoices for or on behalf of such third parties, and in collusion and connivance therewith with the intention of defrauding or cheating SRMB. Misutilizing the subsidized rates which has been provided to you for enabling you to compete effectively in your designated geographical area under the said agreements. And then paragraph 8, which is at page 26. Accordingly, we are terminating the said agreement forthwith and with immediate effect, and all entitlements thereunder are to cease with immediate effect. You are called upon to return to us all articles and products bearing or containing the SRMB mark which are in your custody and possession. Our authorized representative will reach you in due course of initiating such and such matters, termination and then subsequent. Paragraph 9. This issue strictly without prejudice to our rights and contentions, all of which are expressly expressed. We further express expressly reserve our right to recover appropriate damages from you for the loss occasioned due to your breach of the said agreement as aforestated. So, my lord, there the dealership has not been disputed. The product is not been disputed. Admittedly, after an order being passed by this honorable court, they have subsequently terminated the agreement. Now, one of the argument put across was, since I have terminated the product, now they cannot acquire the goods from Mishra Steel. I will definitely not till that time, because my argument is under section 30 I am being protected if I am legally acquiring it from any person. I do not fall within the definition of infringement. And I am not infringing the goods
So,
today.
so at present, there is no dealership with the Mishra. Correct.
Correct, my lords.
So
And
you cannot acquire from Mishra.
exactly. So, my lords, what is interlocutory injunction? So, my lords, I am not. I'll circulate the judgment. My lord, there is a judgment of Honorable Supreme Court, and in fact relied upon by the High Court of Calcutta, my lords, which says where important assertion with respect to interlocutory stage has been dealt with by Lord Depling. I'll just read for a second, my lords. A right to obtain an interlocutory injunction is not a cause of action, my lords. It cannot stand on its own. It is dependent of there being a pre-existing cause of action against the defendant arising out of an invasion actual or threatened by him. My lord, there is already a suit pending. In a suit, there is no amendment as on date. The suit alleges that I have infringed the goods because I have procured the goods from third party. There is no evidence which has been annexed along with the plaint. There is an injunction application being filed that look, he is infringing my goods because he has obtained it from X or maybe n number of persons. I come before this honorable court. I substantiate that the fact that whatever goods when this suit was being filed, I am not talking about the future. Whatever goods which has been procured by me falls within the definition of non-infringement because I have procured it from the market through your own dealers. Now, subsequently, you want to claim damages for an act which has been done by your damage. You are separately invoking an arbitration clause. Dealer is not a party to the present suit matters. So, what happens? Whether this is an infringement and what circumstances, at least as a prima facie stage, my lords, I am still satisfying the ingredients. And
No, that's correct. That's correct. Now, as on today, because at identity mistake, the situation was different. Now, today, the situation is different. Today, what you are claiming with regard, you are selling, you are purchasing the property from the Mishra Steel and you are selling it. So
correct.
that's why this court has not granted interim. Now the situation has changed. Now they have cancelled or terminated the dealership with the Mishra Steel. So if the Mishra Steel is cancelled, so naturally you cannot purchase anything from the Mishra Steel with regard to the SRM, whatever it is.
Correct, my lords.
So if it is not, so if the order is passed, you cannot sell the property and sell the the materials of the defendant in the open market. What prejudice will be caused to you?
No, my lords, I have no prejudice. That's the reason, my lords, there was a one pager order which I have initially annexed which was a Gupta store order, which simply says that I will be allowed to sell the products which I have legally acquired.
Correct. That's I'm telling.
That's an order. I am okay to be invited. I am not going to sell any products by way of any infringement. I am going to sell the products which I have legally acquired. My lords, that order I have already annexed at the time of argument, which was Heritage Marketing versus Gupta Steel, Gupta Store. So I have no difficulty. I am not going to infringe upon. My argument has always been today, if my lords pass a blanket order that you are injuncted from selling the goods, tomorrow, if I am acquiring it from third party, I will be restrained from even acquiring it from third party, which the statute gives me a right. They cannot control
then if with regard to the third party, then there will be a condition that the liability of the persons from whom you have purchased.
No, my lords. Then, my lords, Then one, yes, now the argument which was being put across, I give a warranty and everything. My lords, may have there any of the advertisements which is a part of their plaint. There is no warranty as far as this product is concerned. No warranty being given, my lords. My lord, these are used uh, for construction. Those construction maybe 10, 20, 30 years down the line. Let them show any warranty virtue of the pleading where they say that they have given a warranty for a particular product. My lords may have their advertisement. I can come across to their advertisement, my lords. I'll just refer to those pages. My lords, not a single page, not a single. My lords may have page 49, annexure E of the application, my lords.
Yes.
Now this is their advertisement.
Yes.
Not a single. This starts from page 49, my lords.
Yes.
And goes up till let's make come down.
62.
62, my lords. Nowhere, anywhere they talk about this warranty aspect. Now, this warranty proposition was put across on the basis of Kapil Vasva's judgment.
Yes.
My lord, there the facts were different.
Yes, that is electronics good. Yes.
That was an electronic goods. My lord, these are the goods. Once a building is being constructed, no one gives that warranty.
Immediate use, and you cannot. Yes.
Definitely, my lords. And even on their website, they are not giving this warranty. What they are claiming today that there has to be a warranty. My lord, these are being sold in open market through different sources. Ultimately, what I need to satisfy this honorable court is whether I am selling the genuine goods or not, which I am able to satisfy, my lord. There is no question of warranty being given, or
Yes.
I putting a hoarding that I am in fact willing to have that dealership also.
Correct.
They don't want to give. That's a different aspect, my lords. What is the question? If I am selling these goods in the open market after I am procuring it legally, they cannot stop me. The law protects. And that's the reason there is no question of any warranty or being substantiated. So today, my lords, in fact, I am willing to, I am a person who is not inclined to fight big fish. But because of this injunction or any injunction, I should not be stopped from doing my business.
Okay.
So, my lord, that's a short argument. And as far as, my lord, that subsequent event is concerned,
What judgment you are relying?
That is Adhunik Steel judgment, my lords. Adhunik Steel versus Orissa Manganese and Minerals Limited, my lords.
Citation?
My lords, citation would be 2007 7 SCC 125.
2007
7 SCC.
SCC.
125.
Volume? 2007 volume 7 SCC page?
125.
Okay.
Well, it talks about what is the simpliciter interlocutory injunction application. It will definitely, my lords, today what they are claiming, they have to first plead that particular aspect. Or in fact, there are other judgments also that once there is some allegation per se and there is some development, there has to be an Order 6 Rule 17 application which they necessarily need to file.
Yes.
Even while determining Order 39 1 and 2, my lords,
Yes.
617 should be kept in abeyance till the time that Order 39 1 and 2 has been decided.
Correct.
Because what you have pleaded, you instituted a suit on a basis of cause of action.
Yes.
I'm able to satisfy that cause of action is not maintainable. In fact, this is the case now till the time they don't amend. This is a case where Order 13A needs to be there. The suit needs to go by virtue of the Commercial Court Act, my lords.
Okay. That's all.
Nothing survives, no cause of action as on date, my lords. And Gupta story is one of the judgment which I'll be relying. My lords, I can file that judgment, my lords.
Yes, give the judgment. What are the judgment?
A brief note if required, because I didn't want it to argue much, because this was already argued at length, my lords.
Lordship, may I just peruse the judgment and come back? Lordship, keep
Okay,
it.
you saw the when you give the judgment, you or give the citation to the other side.
I've taken down the
I'll,
citation.
I'll right away give the citation.
After, as per your Lordship's convenience.
When you will come?
Tomorrow or the day after, as per your Lordship's convenience. Whenever your Lordship wants.
So and so appearing for the plaintiff, so and so appearing for the
My
defendant.
learned friend has
counsel for
also
the
given some
defendant.
proposals while he was arguing. So if your Lordship wants, I can take instructions.
That's
Because
also
he has offered-
because he's telling that his
Yes.
proposal is that now you have cancelled.
Yes, yes.
So he is not going to purchase.
Yes.
And
he has
that
also-
only his statement I will record that they will not sell any materials which is illegally acquired. That's all.
I'm 100%. This was the first thing I saw.
He's not going to sell any product which is illegally acquired. That's all.
And I believe they have also
I'm willing.
they are agreeable to take my dealership. So they have also submitted today that they are agreeable to take my dealership.
That is up to you.
Yes. So let me take instructions.
That you say, either you sit with
Yes,
Mr.
yes.
Kumar or sit with
My
the
learned
party.
friend will have to reach out to.
So you want the long date?
Keeps it next week. Then let me take
Then
instructions.
you come after vacation.
Lordship, there is some urgency. Keeps it next week. We can take instructions and come back.
Appearing for the defendant, counsel for the defendant has concluded his argument and is relying upon two sides and he submits that he will file the short written notes of argument. Full stop. Counsel for the plaintiff press for time to deal with the citation relied by the plaintiff, relied by the defendant. In view of the above, the case is adjourned. Let the matter appear on
any day next week, your Lordship.
On 7th May 2020.
7th. I'm grateful.
Obliged.
Grateful.
Yes, next.
26 is my application for revocation of clause 12 granted under letters patent.
Revocation of clause 12.
Clause 12 under letters patent. Your Lordship, the learned advocate for the petition.
Which was the other?
Lordship, the
Apatatto. Nobody is there.
Lordship, they were here a while before, but I believe, Your Lordship, since it's nearing 1:15, they've
not today.
Very well, Lordship.
Next.
Well, I appear for the plaintiff petition in this matter, Malad. Well, it recalls that the defendant number 1 had taken out an application for deletion of the name. Well, the defendant number 1 now has gone into CIRP, Malad.
CIRP, yes.
Yes. And Malad, we are proceeding against the defendant numbers 2 to 7. Now, Malad, on the last occasion, I had made submissions,
What
Malad.
about the defendant number 5? Service of notice?
Service of notice, Malad. It has been served. The affidavit of service, Malad, is being affirmed, Malad. It has returned with the endorsement unclaimed on the envelope. So, Malad, of course, I'll be proceeding with the rest of the defendants thereafter. So, Malad, fixes any day so that I can have the matter heard out because none of
nobody is appearing.
Apart from defendant number 1, Malad, none have
Which was
appeared.
appearing on defendant number 1?
Malad, Mr. Kumarjit Banerjee was appearing for the defendant number 1. Now, Malad, the defendant number 1 has gone into CIRP. So,
He
they
will not appear.
Perhaps not because unless the RP Malad decides to appear.
Until RP will give the authorization, then
Yes.
he will file an vakalatnam and he will.
Or else
you
Malad,
have
the
to
RP
substitute that.
Yes, that I'll have to. But Malad, again, there will be a moratorium, so I cannot proceed yes, against the defendant number 1. So I can proceed against the rest of the defendants, Malad.
Order has to be passed.
Malad,
Let the defendant number 1 come and say.
Malad, perhaps that was recorded on an earlier occasion, Malad.
File an affidavit service.
Malad, it was
Moratorium under section 7.
Yes,
So
yes.
consumer prays for time to take appropriate steps.
Malad,
Okay, I am suffering for the plaintiff. Then appears on behalf of the defendant. As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on
whenever you lodge.
after vacation. Let the matter appear on 12th June.
June, Malad. If it can be before the vacation, so I can proceed.
Okay,
at least.
20th May.
20th. Very well. I'll be here.
20 May. ये खत्म कर इसको.
Sir, CIRP तो चला गया. Well, I'm for the
petitioner, my lord. This is that Order 7 Rule 11 application. It's now 1:20. Lordship, do we have a fixed matter before the division bench, Lordship?
Not today.
Not today, that's all. I will come.
27, not 28, not today.
Grateful.
29. In this matter, I am led by Mr. Shubhankar Nag, my lord. I am appearing for the defendant, my lord. Defendant.
Who is for the plaintiff?
Lordship, I'm appearing on behalf of the plaintiff.
My lord, I am praying for the password.
Not today.
Lordship,
Obliged.
kindly give me a short passover, please.
Yeah, 2 बजे का matter है.
Obliged, my lord.
After lunch, there is no time. All matter is fixed. Not today. Come tomorrow with us.
My lord rises. Since 2 p.m. there is fixed matters. Item 33 is an undefended suit, my lord. File my judge's brief of document and my lord will fix a matter for witness action, my lord, any day. But my judge's brief is ready, my lord. I need an extension and I'll file it here and now. Item
What?
33. It's a judge's brief of document.
Who is the undependent?
Undefended suit, my lord. I'm the plaintiff.
So you go for the commission. Why you are not going for the commission?
My lord, we can go. Yes, my lord. Subject to if my lord directs, we can go for commission also.
That is better.
Yes, my lord. That possibly. But I have to take instructions.
Okay, come tomorrow.
Tomorrow, my
Take
lord.
My lord, my lordship, my lord, item number 30, your lordship. I appear for the defendant. My application under Order 8, Rule 1 of the Code of Civil Procedure.
Order 8, Rule 1.
Yes, your lordship, for extension of time. My lord, the written statement has already been filed with the leave of this honorable court, your lordship. On 21st of March, my lord, the application had appeared and the 21st of March, written statement had been filed. My lord, your lordship had passed an order on my lord on 1st April. My lord, the application was listed before your lordship, and where the plaintiff had sought for time to file an opposition. My lord was kind enough to
Who
give
is for the
time.
plaintiff?
My lord, one Rishita Sarkar and Srinita Ghosdostidar had appeared, your lordship. They have not served any in any opposition till date, my lord.
Okay, not today. Let they come, or if after lunch at time permit, I will take this. If the fixed matter will adjourn, then in matter will be taken.
Your Lordship, item number 31
Ah.
is an undefended suit. The matter has been transferred to the commercial division by an order of Honorable Justice Sugato Mojumdar. And yet, and as of now, no one has entered appearance, and it has not been delivered. Has not been.
Have you taken steps in terms of the Commercial Court Act?
Yes,
What steps you have taken?
We have again served the writ of summons, and it has again come back to the registry undelivered because according to the residents who are in the address now, no, the persons by name of the Vishnu Nama or somebody related to it do not stay.
So you have to take fresh steps.
Your Lordship, I'm praying that the matter be adjourned to June because the instructing person of the client, Mr. Ashok Todi, is not well.
Record an order 31. Sense appearing for the plaintiff. Counsel for the plaintiff prays for time to taking appropriate steps. According case is adjourned. Let the matter appear on 18th June.
Hello, item number 32, 34 and 35. You will not see busy at 2 at 3 p.m., my lord. Rather make it 2 not 2.
No, I will take. If the matter is adjourned, the matter will be.
I will defend before the
You
matter.
can dismiss.
matter is for witness action. I'm for the plaintiff. This was set ex parte. Thereafter, the respondent had appeared and they were present. My lord, the witness is here. I can proceed with the chief. My lord, may I only seek leave to address the court from this side of the table? And my lord, one more issue. My lord, there was one document in the complaint which we had not disclosed in the judge's brief because my lord, at that date we did not have the certified copy. These are documents in relation to NCLT. My lord, I've prepared a judge's brief. I've given them additional judge's brief. I've given them inspection. My lord, it is there in the plaint, my lord. My lord, may I file the document? I think she is there. The copy of the judge's brief I'm handing over now.
Yes. Your name, please.
Ramavatar Kankani.
Ram Avatar.
RAMAVATAR Kankani. KANKANI.
Ready? No, not record. 65 দিয়ে একটা অ্যাফিডেভিট আছে আগের দিন ফাইল করে এটা হচ্ছে আপনার 24 February 2025. Okay. I am showing you a document. Kindly tell this court what this document is about.
सर मैं हिंदी में जवाब देना चाहूँगा सर ये एक एफिडेविट है ऑन बिहाफ ऑफ द प्लेंटिफ
An affidavit on behalf of the plaintiff. And
ये मेरे द्वारा बनाया गया रामावतार कांकानी मेरा ही एफिडेविट है ये
this is my affidavit and prepared on my instruction.
Let us kindly come to page 6 of the document. Can you indicate whose signatures are appearing on this document?
हाँ जी इसमें दो सिग्नेचर है
Two signatures appear in this page.
एक सिग्नेचर मेरे खुद का है रामावतार कांकानी
One signature is of myself, Ram Avatar Kankani.
एंड सेकंड सिग्नेचर जो है कमिश्नर ऑफ ऑथ एंड एफिडेविट्स उनके हैं
And the second signature is of Commissioner of Oaths
and affidavit.
and affidavit.
Where is the original of this document?
Original.
ओरिजिनल कोर्ट में प्लेंट के जमा दिया हुआ
The original is submitted in this court.
What do you have to say about the contents of this document?
सारे कंटेंट सही और सत्य है
All the contents are true and correct.
Madam, may the affidavit be taken on record? The page number from the chart. I am showing you a document appearing at page 2 of the judge's brief of documents. Kindly indicate what this document is about.
सर ये कंपनी मास्टर डेटा है जेएमवी पॉलीमर लिमिटेड का
This is a company master data of JMV Polymer Limited.
How have you obtained this document?
सर ये डॉक्यूमेंट रजिस्ट्रार ऑफ कंपनी अफेयर्स की एमसीए की जो वेबसाइट होती है उसके अंदर मैंने सर्टेन इंफॉर्मेशन पुटअप किया उसके बाद में ये रिपोर्ट वहां से जनरेट हुआ जिसको
I had fed some information in the MCA website of Registrar of
Company Affairs.
And then downloaded it from the company website.
डाउनलोड वहां से किया उसके बाद में मैंने इसका प्रिंट आउट अपने जो कंप्यूटर के साथ में प्रिंटर अटैच है उस पर मैंने प्रिंट आउट लिया
And then taken out the printout of this document from the printer attached with my computer.
बाद में मैंने दोनों को स्क्रीन पे एंड प्रिंट आउट को चेक किया दोनों सेम
Thereafter, I compared both
the printed document and the document in the website
दोनों सेम थे
and found it to be same.
And may I tender this document in evidence, madam? I am showing you a document. Kindly indicate what this document is about.
सर ये मेरे सिटी बैंक अकाउंट का बैंक स्टेटमेंट है स्टेटमेंट ऑफ अकाउंट
He's apparently like evidence is going on. He's not even referred to page number. Which page
No,
number?
I am not. I have deliberately not indicated any page number, my lord, which I wish to indicate now.
How did the witness start?
My lord, if my lord permits the witness to step out, I can indicate exactly, my lord. It is, my lord. It is a copy from the judge's brief, but it is not in the same form as that is there in the. It is not in the same form as that is there in the judge's brief, nor is it this identical same entries, but it is the same document. My lord, I will indicate this is a account statement.
Same document.
I'll indicate
Now you
one.
telling
That is why I indicated that if the witness wants to should be directed to step out, he may step out. I can indicate. And this is the statement of accounts in the judge's brief.
Which you are showing that is the same document.
It is same document. It is same doc. No, my lord, the page numbers where it is appearing in the judge's brief, the form is not the same. I will show, my lord. My lord will take my copy, my lord. Alright. My lord, page number 27 of the judge's brief. 27. Page number 8.
These are completely different things.
No, but it is the same document. It's the same thing. My lord, the issue is here the entries are not for the same same, not page wise. My lord will see it's not the same entry wise, it's not the exact same replica of the copy, but it is the same document. Only issue, my lord, on the last occasion this question was put, the document was not in the original. My lord had indicated at that stage he has obtained another copy, for which now this is the form in which the printout has come out. So that is the only material difference. It is the same document. I am for the same period.
But based on this document, not on the document which now they are, because no, your lordship, that document. No, I am saying something else, your lordship. The document set of documents which are being handed out, that is not the same as in the legislative brief.
Let me put the question. Let the witness give answer, and the court will see.
About. And my lord, if my lord so wishes, it is between, yes, page 27 to page 36 of the judge's brief.
अभी बताइए ये डॉक्यूमेंट क्या है?
सर ये हमारे सिटी बैंक के अकाउंट स्टेटमेंट है एक
This is the account statement of my account in the city bank. बताइए
1 दिसंबर 2018 से लेकर के 10 दिसंबर 2018 तक का
from 1st December
ये वैसे है 1 दिसंबर
अच्छा 2018 to
10th दिसंबर
2018.
Your lordship, may I just be heard for 1 minute? This is not even a legible copy, and he has been given some other copy which is legible. No, 1 minute. The one which has been supplied and which is in the record of the court.
Record your evidence. Record your let the witness examine first.
No, witness is saying something. If he was just given this, he wouldn't be even able to read what is there.
See, judge's grade document is the certified with the Xerox copy is given and produce the original.
If the original is produced, they are not producing an original.
Let me complete the evidence.
Very good. Very good.
How have you obtained this document?
सर ये स्टेटमेंट ऑफ अकाउंट जो है हम लोग सिटी बैंक को डे टू डे ऑपरेशन में यूज करते हैं सिटी बैंक हमारा प्राइम बैंकर है
The account that I maintain with the Citibank is used for day-to-day transaction.
ट्रांजेक्शन
उसके बाद
सिटी बैंक हमारा प्राइम बैंकर है
Citibank is our prime banker.
हमने इस स्टेटमेंट को डाउनलोड करने के लिए हमारा जो डे टू डे यूजर आईडी पासवर्ड है वो डाल करके स्टेटमेंट को वहां से डाउनलोड किया
To download this statement, I had put the user ID and then downloaded it from the website.
Where did you put the user ID and the password for the purpose of downloading this document?
सर सिटी बैंक का एक वेब ब्राउजर है www.onlinecitibank
There is a web browser of the Citibank, namely www.
.online.citibank CITI.in
How have you obtained this document from the particular browser for the purpose of producing before this court?
सर इसको मैंने स्टेटमेंट को वहाँ कंप्यूटर पर डाउनलोड किया फिर अपने कंप्यूटर से जो अटैच्ड प्रिंटर है उससे प्रिंट आउट निकाला
I downloaded this statement from the website and then taken the printout from the printer attached with my computer.
Where is the original of this document?
ओरिजिनल मेरे कंप्यूटर पर है सर
The original is in my computer.
After taking the printout, did you take any steps for verification of this document?
यस मैंने इसको और अपने स्क्रीन पे जो डाउनलोडेड था दोनों को चेक किया दोनों सेम
I compared this statement with the downloaded copy in my screen and found it to be the same.
When did you obtain the copy which you have produced in court today?
अब आपने ये कॉपी आपको मिला डाउनलोड किया
ये जिस टाइम अपना केस चल रहा था उस टाइम डाउनलोड किए थे
at the time when the suit was pending before court.
What do you have to say about the contents of this document?
सब सही और करेक्ट
True and correct.
Three objections. First objection, the document produced before the witness is not the same. The document here is ineligible, which is there in nothing can be read at all. One. Second thing, banking document. Yes, yes. No, no.
Well, since this is an ex parte suit, no direction for inspection was.
But your lordship, the document which is there, or my objection was the document which is there in records of the court has to be shown to the and not some separate document. The second objection is, your lordship, with regard to banking documents, a different law applies. Banking documents cannot be proved. Veracity of banking documents cannot be proved by this statement. It has to be under a different evidence law altogether. So this cannot be taken on record because without the authentication from the bank. Your lordship.
Exhibit. What is the exhibit?
E.
Exhibit D with objection. Within bracket, the concept for the defendant has been protected on the ground that the documents appearing in the judge's brief of document from page number 27 to
36
are not the physical document which the witness is producing, and the document which the witness relied upon is the bank statement. If not been issued by the, it's not been is covered under the other banking regulation.
Evidence. Your lordship, under the appropriate law of evidence, not verified by the bank under the appropriate law of evidence.
Not verified by the bank under the appropriate law of evidence.
I am showing you a document appearing at pages 40 to 45 of the judge's brief of documents. Kindly indicate what this document is about.
ये सर डिमांड नोटिस है 7 फरवरी 2020 का बना हुआ
40 to 45, my lord.
This is a demand notice dated 7th February 2020.
Who had issued this demand notice and to whom was it addressed?
सर ये हमारी कंपनी की तरफ से जेएमबी पॉलीमर लिमिटेड जो डिफेंडेंट है उनको इशू किया गया था हमारे एडवोकेट की तरफ से आफ्टर आवर गाइडेंस.
This demand notice was issued from our side, issued by our advocate on our instruction to JMB Polymer Limited. Defendant JMB Polymer.
Where is the original of this document?
ओरिजिनल सर डिफेंडेंट के पास है.
The original is with the defendant.
Are you aware as to whether the defendant has received this document?
Yes sir. देखिए एक तो इसके ऊपर में मैंने स्पीड पोस्ट का ये एक्नॉलेजमेंट लगा हुआ है और
Yes, because the acknowledgement slip is attached with this document.
एंड उन्होंने अपने इस लेटर का रिप्लाई भी नेक्स्ट एक रिप्लाई भी बना करके सबमिट किया.
And he
So
had
that means कि उन्होंने रिसीव किया.
and the defendant had also replied to this letter later on.
That means उनको रिसीव हुआ.
This means that he had received this letter.
On the basis of the postal tracking consignment number, did you make any inquiry as to whether the defendant has received this document?
सर एक ट्रैक रिपोर्ट निकाला गया था सिस्टम से इंडिया पोस्ट के वेबसाइट से.
One track report was downloaded from the website of India Post.
India Post.
কপি আছে কপি নিয়ে কোর্টে দিতে হবে. Can you indicate as to what is this document?
How can
Well, it is not there. Well, I will not. Well, this is the tracking
report. It's not there in this.
It is in the judge's brief. It is sorry. No, it is not there in the judge's.
It is not there in the judge's.
Okay. This is 47, my lord. It is there in the judge's brief. Sorry, my lord. My lord, I'm sorry.
Your Lordship, Your Lordship, problem is I don't have a copy. They have not given me a copy.
No, I can add it.
How will I lose my? They have not given me. See, they have.
It's part of the plaint also. It is part of, my lord, it is part of the plaint as well. My lord, and may I put question 102 and
See, in my court, if you want to adduce the evidence, you have to corroborate your judge's brief of document or with regard to the plaint which you have disclosed the document, then the original or what the copy has to go to the witness. Otherwise, this court will not allow.
my lord, it is part of both of the judges. 102 and 47. 47 of the judge's brief. 47 and 48 of the judge's brief. What is this document?
सर ये वही ट्रैक रिपोर्ट है 5 मार्च 2020 का निकाला हुआ.
This is the track report of dated 5th March 2020.
Can you indicate the consignment number mentioned in this tracking report?
Yes. Event detail for EW 420 699 EW 420 699 698 IN.
Yes, yes.
IN.
How have you obtained this document?
इंडिया पोस्ट की वेबसाइट से निकले सर ट्रेक
I had
करके
downloaded it from the website of India Post.
Where is the original of this document?
सर ये उस टाइम निकाले थे लेकिन अभी ओरिजिनल देखिए मेरे पास नहीं है अवेलेबल क्योंकि ये टाइम टू टाइम आपका सर्वर से हट जाता है तो इसका ओरिजिनल मेरे पास अभी नहीं है
At that time, I had the original, but at this time, I do not have the original because time to time the details in the server changes.
Would the copy produced before you be identical to the original which you have produced in the present
Yes, sir.
proceedings?
Yes.
My lord, may I tender this document in evidence along with the letter, my lord? A letter, I have already put questions. I wish to put one more question before that. What do you have to say about the contents of the letter?
True and correct.
May the both the documents.
F collectively.
Showing you a document appearing at pages 49 to 51 of the judge's brief of document. Kindly indicate what this document is about.
सर ये डॉक्यूमेंट हम लोगों ने जो डिमांड नोटिस रेज किया था उसके अगेंस्ट में उनके एडवोकेट मिस्टर राधेश्याम तिवारी एडवोकेट जो है उन्होंने हमारे जो एडवोकेट है SK ककरानिया एंड कंपनी उनको रिप्लाई बना के दिया था
This is a letter that Mr. Advocate Radhesham Tiwari
How did the advocate for the plaintiff receive this document?
ये यूजुअल कोर्स ऑफ बिजनेस में सर बाय स्पीड पोस्ट उनके पास पहुंचा था
This was received through speed post in the usual course of business. May I tender this document in evidence? Yes, ma'am.
Exhibit G.
I am showing you documents appearing at pages 52 to appearing at pages, a copy of which is appearing at page 52 to 69 of the judge's brief of documents. Can you indicate what this document is about?
सर ये हमारे डायरेक्टर और मनीष जी लखोटिया के बीच में व्हाट्सएप चैट जो हुआ था उसका एक्सट्रैक्ट है ड्यूरिंग द बिजनेस टाइम्स
These are the extract of the
WhatsApp
conversation, WhatsApp conversation in WhatsApp between our director
and Manish Lakhotia of JMB Polymer Limited.
Manoj Lakotia of JMB Polymers Limited.
How have you obtained this document?
सर ये जो व्हाट्सएप चैट है वो जो हमारे डायरेक्टर है उनके मोबाइल पर था उनके परमिशन से मैंने अपने कंप्यूटर में एक्सेस किया व्हाट्सएप वेब ब्राउजर के थ्रू उसको वहाँ डाउनलोड किए उसके बाद उसका प्रिंट आउट निकाल के अपने कंप्यूटर से जो प्रिंटर अटैच था उससे प्रिंट आउट निकाला फिर उससे उसको कॉरेस्पॉन्डिंग चेक किए दोनों सेम
With the permission of our director, I had accessed the WhatsApp chat, then downloaded the chat from the web browser, and then took the printout from the printer attached with my computer
and both are identical
and compared the printed copy and the copy in the computer and found it to be identical.
And one statement which has not gone down is this conversation had happened in the phone number of the director. That was the first statement. That perhaps has not gone down.
This WhatsApp chat had been in the
WhatsApp chat conversation between our director and the expert.
There are objections once they finish.
Where is the original of this document?
Sir, original मेरे computer पे download.
The original is downloaded in my computer.
What do you have to say about the contents of this document?
That prevent करे.
That may I tender this document.
Exhibit H.
And WhatsApp, Facebook, photos from the WhatsApp cannot be exhibited like. But how it is. There is a 65p.
Well, 65 is here, man.
Page 3, paragraph 6b.
Not the problem. Not the problem. There is a guidance of how this WhatsApp messages.
Yes. JPG contents, and it has to be done in JPG file format.
May I take 1 minute time?
Also, your lordship will have a look from page 4. When you download and print, you don't get page numbers below. And then from page 4, it goes to page 24. From page 4, it has gone. Next page is page 24.
Oh, those are two different. Very well.
Very
Well, I shall take steps on that, man. Let it remain on record if required, but it is not exhibited. Yes, my lord. It's a. I'm showing you documents appearing at pages 74 to 91 of the judge's brief of documents and pages 1 to 118 of the additional judge's brief of documents and 1 to 212 of the judge's brief of additional judge's brief of documents. Kindly indicate what these documents are about. Pages 74 to 91 of the judge's brief of documents and my lord page 1 to 212 of the additional judge's brief of documents. Kindly indicate what these documents are about.
Sir, ये first वाला जो है वो application under section 9 of insolvency and bankruptcy code.
The first document is an application under section 9 of the insolvency and bankruptcy code
2016.
Kindly indicate what the other documents are.
Second one is sir ये petition है before the Honorable National Company Law Tribunal Bench. Company petition number is 726 of 2020.
The second document is a petition
এখানে আছে তোমার তোমাকে একটা
bearing number 726 of 2020 before the Honorable National Company Law Tribunal, Kolkata bench.
ये उनकी तरफ से रिप्लाई जो आया है उसके अगेंस्ट में.
This is the reply from the defendant or
ये rejoinder affidavit.
And the last one is the rejoinder affidavit.
How have you obtained these documents?
सर ये हम मेरे कहने पे मतलब हमारे वकील साहब जो मैसेज एसके ककरानी एंड कंपनी है, उन्होंने नेशनल कंपनी लॉ बोर्ड में एप्लीकेशन डाला था, और आफ्टर सर्टेन इंफॉर्मेशन या जो भी प्रोसेस है वो लोग का, उसके बाद में वहाँ से सर्टिफाइड कॉपी भेजा।
Do I have a copy here?
That's it.
I can't. Let may I tender this document in evidence? Yes, madam. Yes, madam. Ledger गुलो दिए दो कर. I am showing you documents. Huh? To barcode. Alert. I wish to show certain documents from this record to the witness. May I be granted that leave, madam? It on documents appearing at pages 158, sorry, 152 to 155 of the judge's brief of additional judge's brief of documents. Can you indicate what part of exhibit H collectively? Can you indicate what these documents are?
सर ये डॉक्यूमेंट जो है वो जेएमवी पॉलीमर लिमिटेड ने बनाए हैं, लेकिन हम लोग को कभी भी ये रिसीव नहीं हुआ है। और इसमें जो मनीष लखोटिया जी ने एज ए डायरेक्टर साइन किए हैं, उस टाइम वो डायरेक्टर भी नहीं है कंपनी के, जो कि मैंने जो फर्स्ट जो कंपनी मास्टर डेटा दिया है उससे आप चेक करवा सकते हैं।
These are the documents issued by JMB Polymer Limited but never received by us, and in the bottom Manish Lakhotia has signed this document, but at that time he was not the director.
But as per the master data, you use
Director.
That is it.
Objection to this answer because there is no reference to the affidavit. In the affidavit of evidence, there is nothing.
I'm showing you documents appearing at pages 37 to 39 of the judge's brief of documents. Kindly indicate what these documents are about.
सर ये लेजर स्टेटमेंट है हमारा कंपनी का, जेएमवी पॉलीमर लिमिटेड के साथ में जो ट्रांजैक्शन होते हैं उसके लिए।
This is a ledger statement of our company with the JMB Polymer Limited
From April 18 to March 19.
from April 2018 to 31st March 2019.
Who has prepared this?
ये डॉक्यूमेंट मेरी
क्वेश्चन है ना,
सर ये मेरे अकाउंट्स टीम ने बनाए हैं मेरे कहने पर।
My accounts team has prepared this document on my instruction.
Where is the original of this document?
Original sir मेरे कंप्यूटर पर।
It is in my computer.
How have you produced this document before this court today?
सर मेरे कंप्यूटर में जो है वहाँ से मैंने अपने जो कंप्यूटर के साथ में जो प्रिंटर अटैच है वहाँ से प्रिंट आउट निकाला, दोनों को चेक किए हैं, सब आइडेंटिकल।
I took the printout of this document from the printer attached with my computer and then checked the printed document and the document in the computer and found both to be identical.
What do you have to say about the contents of this document?
Contents are very correct and true. सही और सही.
Contents are true and correct.
Kindly refer to the document appearing at page 39 of the judge's brief of documents. On what basis have you prepared this document?
सर ये इंटरेस्ट कैलकुलेशन है. डेली बिजनेस जब इनसे होता था तो एक सर्टेन पीरियड का ग्रेस रहता है, उसके बाद में इंटरेस्ट बेरिंग रहता है. जो हमारा सेल्स उन लोगों को जो हुआ उसके बाद में अगर डिले होता है तो उसमें इंटरेस्ट चार्ज किया जाता है, जो कि है स्टेटमेंट ऑफ इंटरेस्ट कैलकुलेशन.
This is the statement of interest calculation as per our daily day-to-day transaction with the
Defendant company. If they do not pay on
If they do not pay the
timely
do not pay the amount on time.
This is owing the interest is paid by the defendant. And the defendant failed to pay the amount on the agreed date.
On what basis and documents have you relied on for the purpose of preparation of this particular statement?
सर इसमें देखिए इनवॉइस नंबर है, इनवॉइस का डेट है, इनवॉइस के अमाउंट है, ड्यू डेट डाला हुआ है, फिगर है, उसके बाद में किस किस दिन में उनका पेमेंट आया जो कि बैंक स्टेटमेंट में भी शो करेगा. उसके बाद में ये कैलकुलेशन बनता है जिससे ये इंटरेस्ट अमाउंट अराइज हुआ.
As per the invoice date, invoice number,
Document is prepared on the basis of
Invoice number, invoice date.
invoice amount, due date, amount, and amount to be paid on particular date, number of days, and the interest.
Did you rely on any particular document while preparing this chart?
Yes, वो स्टेटमेंट ऑफ अकाउंट जो है हमारा लेजर स्टेटमेंट.
Yes, I relied on the statement of accounts and the ledger statement.
Ledger statement and bank statement.
And bank statement.
What do you have to say about the contents of this document?
Contents are very true and correct.
May I tender this document?
Exhibit I. Huh? No, my lord.
My lord, it is his document, my lord. My lord, my lord, he has already answered. It's a digital document. The original is on his computer. So no, the answer has gone in that way. My lord, my lord, my lord. My lord, will kindly look at the document appearing at page 39 of the judge's brief. I had done it in that particular manner, but since I am to produce the original, then I have taken out a printout of that, of the judge's brief, my lord. That document I had prepared in that manner, but since it is a original computer generated document, then I have again taken fresh copy of it from the computer for produce.
Whatever the document we have relied upon, who will authenticate?
My lord, he has already given that answer, that he has prepared it. Yes, my lord. Yes, my lord.
Where is the signature, seal and signature? Prepared by me, compared by me.
My lord, he has given those answers that he had taken.
That's correct. That is not disputed. He has prepared, but the document which you want to exhibit,
Yes, my
the
lord.
document does not bear that signature, seal, or anything. Which date he has prepared.
My lord, with regard to the particular document, I can put questions, but he has given that answer, my lord, that it has been prepared by him, and he has verified.
Prepared by him. prepared by the computer. Your computer cannot be exhibited here.
Because
Suppose plate. You are finding the plate. You are preparing plate in the system.
Yes, my lord.
After taking out the print, it has to be affirmed.
My lord.
Then has to be placed before the court.
My lord.
Only you can say that online you are giving the court can accept this.
All the three pages, 37, 38, 39. But plaint, my lord, may I refer to a copy in the plaint, my lord? Volume. My lord, page 60, 67. 67. Same thing.
That time asking, where is that?
My lord, since this is the original. Achha.
How did you know? How you are identifying the original? Either original.
It will be signed.
The document which you relied upon having the seal and signature.
But my lord will kindly keep the particular document on record, not mark as an exhibit. My lord.
Next.
My lord. It's an exhibit, no? My lord, next are two documents which are part of the judge's brief, but both of them, my lord, will only consider that both of these perhaps may not be required to be exhibited. My lord, this is one is a non-starter report, one is the report from the registrar. So, my lord, in that case, my lord, I'll take him through the plaint, my lord. My lord, may documents would it be my lord's pleasure that we file these documents on record, because these are the originals. Has been. My lord had passed the order in 2024. Indeed, my lord. Very well, my lord. शेष हो जाएगा. Yes, my lord. Yes, my lord. I am showing you. Kindly identify what is this document.
Sir, ये plaint है. This is plaint.
Who has filed this plaint and against whom?
ये मैसेज एस ककरानिया एंड कंपनी जो हमारे एडवोकेट है उन्होंने प्रिपेयर किया हमारे गाइडेंस के थ्रू और अगेंस्ट जेएमबी पॉलीमर लिमिटेड है ऑन बिहाफ ऑफ मारुति पैकेजर प्राइवेट लिमिटेड.
Advocate S. Kakrania and Company had prepared this document on our instruction, that is Maruti Packages Private Limited, against the JMB Polymer Limited.
Kindly come to pages 24 and 25 of this document. Whose signatures are appearing on this document?
ये मेरा सिग्नेचर है सर.
This is my signature. Page number
24.
Is there any other signature appearing at
एक
page
हमारे
24?
एडवोकेट श्री शिवरतन जी ककरानिया के साइन.
Yes, there is one sign of our advocate Shri Ratan Kakrania.
Can you identify the signatures that are appearing at page 25?
हाँ, यहाँ पे एक मेरा सिग्नेचर है और एक कमिश्नर सर के हैं, कमिश्नर फॉर ओथ एंड एफिडेविट्स.
Page number 25, my signature appears and another signature is of Fourth Commissioner.
What do you have to state about the contents of the plaint?
Contents are true and correct.
The contents of the plaint are true and correct.
In respect of the plaint, what is the amount that is due and payable according to you?
Sir, the amount is 79,62,955 rupees and 40 paisa.
My lord.
We are the handicap. We are the handicap.
My chief, in respect of the witness is over. My lord.
Yes. With regard to those two other documents, you will know.
Those two, no, the WhatsApp communication and the not at least not with this witness, my lord, so far.
Will you have another witness?
Maybe depends upon your cross examination.
Very well, your lordship will decide when to do the cross examination. I'll start then. Gives us any date, your lordship. Not today. I didn't think that you. Yes, I know, but the thing is, perhaps your lordship will give us a date, any date. I'll come back.
Thank you.
আগে ছোটবেলায় খুবই কেউ থাকতো না নারীদের শিক্ষাগত মিলে চলে যেত মনে হলো চেপে যেত এই
One date before Thamavik. One date. One date. This is how much?
July.
July.
March of 15th of July.
That is too far.
I heard today morning as well, my lord. It was indicating that if you want a fixed date, it will go in the night.
No, that's their witness. I cannot really push it.
Much obliged, man.
2 o'clock?
3 o'clock.
But
Much obliged.
Item number 30. Item number 30, I appear for the defendant, your lordship. My application under Order 8, Rule 1, for extension of time to file written statement, well, the written statement has already gone in on 21st March, your lordship, pursuant to your lordship's leave. My lord, application, yes, your lordship, GA3, my lord. My lord, one Miss Rishita Sharkar and Shinita Ghosdostitar was appearing. But they had sought time to file affidavit in opposition. But till date, no opposition has been filed. No opposition has been served, your lordship. At least on us.
It's better. No, 32.
Well, the suit is pending, your lordship, before your lordship. Writ of summons was issued, my lord. My lord. My lord, I have not obtained the report, so my lord will kindly give a direction.
In this matter, my lord, I am for the plaintiff. This is the report, my lord. Service. Service was effected on 27th September 2024, my lord. Parvas Gyan, my lord.
Parvas Gyan carrying the business of Gita Enterprise.
Under the name of Gita Enterprise.
Then,
It should be fixed for undefended. Yeah, I'll give the certificate, my lord. The entitled parent but no statement is filed.
the depending on the 27th September and to the postal service, it was served upon and January 27th January 2025. No written statement on behalf of the according to Form 757 based in the list of five agencies.
As you know, I am without.
Seventeenth of by add should be and I am also able 24 January 2025 directed by the meetings and affidavit of document in spite of this not as far as even when it was told no evidence that the matter is the list of warning. Next, the report.
My lord, I have plenty. This is the report. Okay, my lord. Only difference in not interference in this matter, my lord. Yes, my lord. I have given the distribution report. Yes, my lord. Plenty of the same party, my lord. Independent.
Yes, on 760 of the list of different. 70.
I much obliged. In this matter, I have heard the plaintiff, the defendant filed the written statement. Yes, my lord.
Yes, my lord, I am for the sole defendant, my lord. I have filed the written statement, my lord. Yes, my lord. No, my lord, the directions were not there and neither were given.
Yes, my lord. I much obliged.
36. 36, my lord, I am for the plaintiff. GA1 is the application of the defendant, my lord. GA1 is the application filed by the defendant, my lord. Yes. For seeking leave to file their written statement. But my lord, 79 days had already been passed. No, my lord.
But they say that the writ of summons was received on yes 18th November. The sheriff report says 18th, but be that as it may, 18th or yes.
No, no.
No, my lord, they have not filed. We have not been notified. But now the 120 days period is already over.
That's why I want whether they have taken the
Not to our knowledge, but they will be able to.
জানুয়ারি 2024 অফিসে ছিল তো আমাদের ফাইল রিসিপ্টটাই তো ফাইল করা সেপ্টেম্বরে রিসিপ্ট করেছে নভেম্বর
November till and the application has been affirmed on 6th March 2025. No, nothing. No particulars. Not even annexed. But it's affirmed on 6th March. Or Lordship, like,
Great.
Made, please.
Well, I'm being led by Mr. Bose, but he's engaged. He's asked me to start, then he will take over. Gives me permission to start. There were total 36 judgments which were cited by them. I have classified these judgments on 4 heads, and this is how they had argued them as well, placed them as well. The first one was that first set of judgments was shown to argue what is the scope of Order 20 and Rule 58. The second proposition, which was sought to be argued, whether Order 21 Rule 58 allows a third party to challenge the execution of the award on the ground of fraud. And thereafter, the third head is if an award is vitiated by fraud or suffers from nullity, then in such cases the court must exercise the powers under Order 21 Rule 58. And the fourth one, this was in response to our argument of res judicata. Judgments were cited that principles of res judicata cannot be attracted in this set of facts. Now, I have accordingly, although the judgments which were handed over to your lordship are in 2 different files, but we have prepared our note, because 36 judgments, if I start distinguishing them one by one, it will I do not know how long will it take. So we have prepared a chart. I'll hand over the chart I prepared for your lordship. I'll give a copy to them. So I'll take a few judgments from that chart and show your lordship how these were cited and on what context. And accordingly, thereafter, we'll proceed to Mr. Bose will, by the time I hope comes back and places 2 authorities on our rejoinder. But they have here indicated those 2 authorities on the last occasion, specifically on 2 particular points, and we'll finish. First, so the first judgment which comes from the category of scope of Order 21 Rule 58, the one judgment has been cited, 2023 SCC Online, Madras 6677. Now, in that judgment, lordship would find it was a case of Order 21 Rule 90. It is in the first volume, first set of cases which were handed over. Case number 22 of that first compilation of the applicant. 22. Yes, serial number 22. Yes, Millard, that judgment. So this was cited, Millard, while arguing scope of Order 21 Rule 58. And Millard, this was also para 24, 26 and 29 was shown. Yes, Millard. Yes, Millard. Now, Millard, this lordship would find the case was of an attachment, it is true, or of an auction. But Millard, this was a case of Order 21 Rule 90 and not of Order 21 Rule 58. The scope of these 2 provisions of the CPC are completely different. Lordship would kindly come to paragraph 32, 33 and 34 of the judgment. This is a judgment of Order 21 Rule 90 and 68 with 64. It has no judgment is not a case of Order 21 Rule 58. 90. 64 read with 90. Lordship would first find it at paragraph 8 of the judgment. Then Millard lordship would find paragraph 8. Then Millard, paragraph 24. The court's inherent power is nowhere in doubt. Authority was cited while arguing this inherent power of court under this. 24, 8, paragraph 8, kindly see order 21 rule 90. That was the application, paragraph 8. Paragraph 24 also talks about order 21 rule 90. Now, Miller, paragraph, Lordship would kindly come to paragraph 32. Paragraph 32, right of an auction purchaser. This is again, Miller, it categorizes, Miller, when such rights arises, Miller, in favor of someone. Page, Miller, this is paragraph 32. Internal page, Miller, 9. $184. Yes. Yes, Miller. Yes, Miller. Therefore, however, Miller. Yes, to set aside the sale. Argument.
If we say that the 58 is not applicable or 90 is not applicable, then what can
But
the submission
maybe, Milord, but Milord, I have read this judgment. This does not talk about the scope of 151. It talks about scope of order 21 rule 90. Milord, I am reading that paragraph, Milord.
inherent power. No, inherent power.
Yes, Milord.
Inherent power under the CPC is only 151.
Yes.
That is a submission.
That is a submission. Milord, that would only come if fraud is established. Yes. So that there, if another argument has been made that in order to even in order to establish fraud, he has to permitted to lead evidence. So
This of the argument is that they have taken the ground of fraud, and the ground of fraud cannot be decided in the summary procedure. If this court find that the fraud is to be decided, that is to be decided during the trial. And during the trial, if this court found that if the fraud is committed, the court can invoke the jurisdiction on the inherent jurisdiction to decide.
that is the. Well, means I wanted to show that this is not applicable. 32, Milord. 32 to 33, 34. Milord. These are three paragraphs I am citing from this report. Though the sale was conducted on 3rd, 2010, it is admitted fact that the sale is yet to be confirmed. Therefore, the right of the auction purchaser is yet to get crystallized. The auction purchaser had challenged the order of executing court before the appellate court successfully. Before the divisional court, the auction purchaser cannot raise a plea that he was not heard by the executing court. Now, Milord, this is completely different in the facts of our case. Here, Milord, the sale in that case, Milord, the sale was, yes, here the sale was not, there was no question of sale here. The question was of attachment of a money decree. Attachment was lifted and the money was already paid to the beneficiary under the award. So, Milord, the court could only, that's why second limb of my argument, that court could only, Milord, invoke jurisdiction if it at all had, or Milord, if he wants to, Milord, only if the stage is the proper stage. In our case, today we are in a stage where the award has been performed. Without Milord, execution proceeding, in execution proceeding, the awarded sum was paid to the beneficiary. So, Milord, that stage we have already passed, and they were aware of this. They appeared in the execution proceeding at the right time. They shown to the court an application to invoke in the execution proceeding, but they did not file that application. Instead, they filed a suit. And in the suit, they lost in the order 711 first partial dismissal, then it went to appeal, full dismissal, and thereafter Honorable Supreme Court. Supreme Court also did not interfere with the order of dismissal. So, Milord, it is not that they were not aware of it or they could not do anything at that point of time. They had the chance, they lost the chance. That's our submission. Mr. Bose has elaborately made arguments on that. I am not repeating those, Milord, on facts. This is the first one. Second, Milord, Lordship kindly comes to serial number 7. The judgment at serial number 7. Avtar Singh versus Gurjit Kaur. Yes, Milord, 1997. Kindly, I would show, Milord, paragraph 2, 3, and 10 are the 4 paragraphs that I want to cite, Milord. They had cited 4 to 7. This was, Milord, on the point that that under order 21, rule 58, if the court finds that the paragraph 4 to 7 was cited by them, yes, the argument was that under order 21, rule 58, if serious disputed questions of fact have been raised, then those can be adjudicated on their merits under Order 21 Rule 58. Yes. Now, my lord, I am showing paragraph number 235. 2 kindly comes to paragraph 2. What was the Millard serious? The lordship would have to measure the case according to the facts of that case. Here, Millard, the necessary facts are that an amount of such and such was with interest was awarded in favor of Gurjit Kaur and against such and such and another on 1990. Against this order, Gurdeep Kaur preferred an appeal for enhancement of the amount. On or about 24th October 1991, Gurdeep Kaur filed an execution in the court of competent jurisdiction. During the pendency of these objections, an application was filed for attachment of immovable property belonging to judgment debtor comprised in such and such areas. Next parameter. The objector, after seeing claims that he came to know of the attachment of this property from one relative and without any delay filed the present objections. The objections have been preferred on the basis that Saudagar Singh and others had entered into an agreement to sell dated such and such 1/3 share of land measuring 13 vigas and odd in the above mentioned Khewat numbers. Thus, the contention was that there was an agreement to sell of the property in question in favor of the objector prior to the order of attachment issued by the court in August 1993. Now, we kindly comes to paragraph 5. This was the serious objection. Before attachment, there was a prior agreement. And during the agreement, suppressing that, attachment order was obtained. Paragraph 5, kindly see. It is a settled principle of law that the court, while determining the rights of the parties under this provision, can record evidence if it considers proper. Seriously disputed questions of fact, especially where they relate to court records, purchase of stamp papers or a plea of fraud should and ought to be normally determined after giving an opportunity to the parties to lead evidence. Under proviso to Rule 58 of the Code of such and such, an exception is craved out to say in what cases the court can decline to entertain such objections. This proviso thus has to be enforced only in the limited cases which fall strictly within the ambit and scope of the proviso. No doubt that the scope of inquiry under this provision is a narrower one, but certainly it is enough to properly adjudicate the claim of the objector. So, the court itself says, the judgment itself says that the scope of inquiry is also very narrow, very narrow. And if you come under the proviso, then the court can dismiss it. Paragraph 10 also repeats the same. It only says that in the facts of this case, the actually trial court dismissed the application on those on the grounds of proviso. The court had overturned and said that no, this is a serious question of dispute involved. Now, that in our case, the attachment, we have shown, and Lordship has also read, 2009 was their knowledge. 2009 in their plaint. Now, from 2009 till 2014, they did not do anything, any step. So, the fraud that they allege is also, if it was actually a fraud, it continued for 5 years. And thereafter, the suit was filed challenging the award. The suit had failed. In that order, and also in the order of the division bench, the courts have held that your allegation of fraud is your imagination. There is no allegation of fraud because the moment you invest money in a company, the money becomes company's money. Then the investors cannot have a claim over that amount of money. And the company has decided to use that money in a particular manner in terms of the law which persisted then. And there cannot be any question of fraud on that. Those are the reasonings given in the order of division bench. That order was challenged. The Supreme Court did not interfere. So, there is no serious question, disputed question involved in this case. These are the same allegations which are being leveled even now. That we had invested money and that money had been misutilized and now we are chasing that same money back. These arguments have been made, facts were shown, and courts disbelieve that argument. So, in these circumstances, there is no serious question of facts. This judgment says that if those criteria is not filled, then the proviso of the section will be invoked and the matter can be dismissed because the scope of inquiry is very narrow. So these are the distinguishing factors in this judgment. So kindly come to the next. I'll show that serial number 8. That my note has come. May I hand over the note? I'll copy to the other side. Copy. I'm giving a copy to my note. It is 1973 1 Andhra Pradesh Law Journal 243, serial number 8. The Lordship would find this is a case, my lord, again, a scope of Order 21 Rule 58 on that head. So this was there was a question of wrong attachment of a money decree. Now, my lord, I will. They have cited page 249. They've shown P 249. Now, my lord, it's very interesting case here, my lord. Order 21 Rule 58 application was considered and dismissed by the court in chambers. And my lord, because of that, the courts thereafter said that this kind of an application where serious questions are being raised can't be disposed of in chambers in absence of everyone else. So this lordship would find at page 249 itself, that a last paragraph of that page, if an application filed under Order 21 Rule 58 is disposed of in chambers without giving any opportunity to the petitioner to show cause, why it is not designedly or unnecessarily delayed, a division bench of this court has held, and then how that application should be dealt with is given. So in this case, because of that reason, lordship would find that at page 251. Page 252, my lord, lordship would compare to second paragraph. In view of the above authorities considered by me, I am of the opinion that in a case under the proviso to Rule 58 of 21, it is incumbent upon the court to give an opportunity to the petitioner to show cause how it was not designedly or unnecessarily delayed, and after taking such evidence thereon within, the petitioner may adduce it must come to the conclusion before it arrives at a decision under the proviso that it was designedly or unnecessarily delayed. The court cannot pass an order of dismissal on the ground of belatedness of delay casually or as a matter of course. It cannot be said that such an opportunity to the party, that it is one. No, he is saying that opportunity I will establish that I was not delayed by evidence. I am saying that one court has already rejected that prayer of. Yeah, this judgment, Lord, yes. Yes. Also, Lord, there was no opportunity was no opportunity was at all given. Not an opportunity of trial. No, opportunity of hearing was also not given. Because Lord, the lordship comes to page 246, the last para, the certified copies of the order and decree furnished by the lower court mentioned in the cost title portion that the application 246, 240 of that report, Lord. The certified copies of the order of decree furnished by the lower court mentions in the cost title portion that the application came up for hearing in the presence of Sri Satyensai advocate for the petitioner. But the order of learned subordinate is a very short one, rejected as it was belated one. Just one line was given. So that will not prejudice the court, obviously. That while passing this order, court was definitely will not. I was trying to only distinguish it on facts, because this will factually absolutely different situation, different, and courts have, and also here in our case they have already exhausted a remedy. It's an alternative remedy. Absolutely. Specifically, those arguments of fraud, those have been taken care of. Yes. Yes. Right. No, because it cannot be used. This particular provision cannot be used as an alternative remedy First you take a route and then you exhaust it and then come back and follow it. Yes. Yes. Earlier suit. Yes. 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 Absolutely. Absolutely. The next one, Lordship would find from our note, Millard, so is the one judgment of serial number 21 in their compilation. This is Millard, in this case, Millard, the question of fraud was investigated. Millard, page number 21, item number 21 of his compilation. Para 24, they have relied upon that paragraph 24 to 28. Yes. But I am showing the paragraph 21 and 32. Yes. To argue that this is not a case of attachment or execution, or it's just a case where the Honorable Supreme Court has exercised its power under Article 142, and said that under that article, court has extreme power to do complete justice, and that's what the court was doing. And this was also on the point of whether corporate veil should be lifted. Lordship would particularly find that at paragraph number 32, Article 142, the Supreme Court has extraordinary powers. I'm reading it, we are of the opinion that holding in Amratal, Prajivan Das and Raid should guide us while exercising the extraordinary powers of this court under Article 142 of the Constitution. The absence of a statutory provision will not inhibit this court while acting under this said article from making appropriate orders for doing complete justice between the parties. The fiduciary relationship may not exist in the present case, nor is it a case of a holder of public office, yet it is found that someone has acquired properties by defrauding the people, and if it is found that the persons defrauded should be restored to the position in which they would have been but for the said fraud, the court can make all necessary orders. This is what equity means, and in India the courts are not only court of law but also courts of equity. This is a case where the Honorable Supreme Court had decided to exercise its jurisdiction under 142, which gives them extreme power. In our case, with the same allegations of fraud, they went to Supreme Court. Had those allegations of fraud been at all true or relevant, or had the Supreme Court thought it to be relevant to exercise those powers under Article 142, the court could. It did not. It relegated them back to this court and said, if you want to agitate in some other forum, you do. Definitely, because the court did not feel to exercise powers under 142 in our facts. And because it's not the case that they did not go there. They went there. This judgment is there. They could have cited. They did not, or maybe probably they did, I don't know. But this judgment is not an authority of any argument made by learned senior friend. It's not a case of attachment, not a case of execution, not a civil suits case. It's a case where in order to find out fraud or the fiduciary relationship between the parties, the Supreme Court under Article 142 can use its extreme power and do complete justice. Definitely, this Honorable Court, I don't think, has that power, that extreme power, and Article 142 is also not applicable. Not in that facts, I don't think the judgment is at all relevant for this case. Next one is serial number 14. Serial number 1, the first judgment of that compilation. It is 2008-14 Supreme Court 258. They have shown paragraph 26 of this judgment. 2008 volume 14 SCC 258, case number 1 of that compilation. First page, first judgment compilation. They have shown paragraph 26 of this report. 26. Now, my lord, this was shown to argue that the Order 21 read with Order 21 Rule 58 read with proviso of Order 21 Rule 110 spell out the duty of the court to adjudicate all the questions relating to the rights of the parties, and the executing court had failed to consider the provisions in the proper perspective and should have decided as to whether the decree between the first and the second respondent is a collusive decree merely meant to defeat the right of the appellant herein. The aforementioned proviso to Rule 58, more particularly Clause A thereof, was the only provision relied upon by the High Court, which is clear from the observations made in the internal page 4 of the judgment. But it is quoted, we have already shown that this is not a situation in law. The High Court further went on to suggest that a merely agreement holder could not prevent the right of the auction purchaser to get the sale confirmed. This statement is also patently an incorrect statement of law. We have therefore no hesitation in holding that the High Court and the trial court were in utter error in relying upon the proviso to Clause A to Rule 58, Order 21 CPC. The appeal has therefore to succeed. The executing court thus shall be obliged to decide the objections raised by the appellant. This was the operating part. Now, that kindly comes to paragraph number 16 of this judgment. Now, my lord, on the basis of those judgments, the learned counsel urge that the objection application in execution petition could not have been therefore thrown away by the trial court, and the High Court are not being maintainable. Considering the law laid down in such and such, it must be said that mere holding of the auction does not bar the objection thereto. It is our considered opinion that in this case, the sale was not confirmed. The sale was not confirmed, and that made a substantial difference. In this case, the sale was not confirmed, and that made a substantial difference. The word sold in Clause A of the proviso to Rule 58 has to be read, meaning thereby a complete sale, including the confirmation of the actions. That not having taken place, it cannot be said that the objection by the appellant was ill-founded or tenable, as has been held by the High Court and trial court. So, and we have shown from our facts that in our case, although this is not a case of auction sale, but the question of attachment, and that's lifted. That proceeding and those orders are no longer exist. The order of attachment, the moment the suit got dismissed, those all orders passed in that proceeding are all gone. Thereafter, the appeal court, they never sought for restoration of any of the orders. Thereafter, the Honorable Supreme Court, even then no orders. It has been paid to the beneficiary. I have not taken. I am not a beneficiary under the award. The beneficiary under the award. It is gone to the through receiver. The receiver is appointed by court. The receiver went to bank, collected the money from bank under the orders of court. Yes, I think so.
The one amount is still deposited in this court, 42 lakhs, etc. The second amount, there's an order in subsistence till date that Ascot, the beneficiary, will retain his identity in his bank account. Those orders are already in force. The money.
I am not in possession of the money at all. It was never my money. It was money to pay, and the receiver has. Yes, may I not indicate a bit more on that? From the day one, the receiver was appointed to collect money and pay it to the beneficiary. That was done. Then they approached the court. The court attached the remaining part of the same of the money in the bank account. Subsequently, when that order was also lifted, the receiver was directed again to take back the remaining money and paid. At that stage, they again applied and said, instead of paying it to the Ascot, keep it to the registrar. That is just a meager sum of 2 lakhs maybe. The order of attachment is gone. That's over. So there is no attachment of any decretal sum now. And my learned friend, senior friend, I'm sure has not shown any order of this court or any court by which the decretal money has been attached or is still being attached or is continued to remain attached. The original order of attachment is no longer there. And they were there before the court on that date. They were aware of those orders. They tried to take benefit of those orders, filed a suit, contested up to Supreme Court, did not get any benefit on that. So, my lord, and that is so, my lord, and also the receiver is acted under the order of court. So there also cannot be any question of any suppression, any fraud. The courts have passed orders. But some senior barrister was there. I believe me that I've taken not probably no longer there. Yes, I guess he has passed away. I do not know Millard. I'll again think. But very senior barrister Millard, who was then appointed, very senior barrister. I again check Millard. I have not seen him for last at least 5-6 years. But that I don't know. He is not a custodian anymore because his bank account, the money was first invested, and then from that account, money had gone to the beneficiary. And thereafter, the second round also, he had his account is there. We do not know that. We do not know.
Suresh Prasad Majumdar was appointed as a receiver, and he was likely to deposit money in the bank where it is still lying. Yeah, as far as it was in the name.
In his name, I think it's his name.
It was receiver with the help of the learned advocate will open a savings bank account in his name in the State Bank of India, Calcutta, and deposit the draft in it, and the bank should not draw withdrawal. So that 42 lakhs something is lying there, and the balance is lying with the beneficiary with the order of this court, saying you will not disturb the identity, and that's the reason why even Supreme Court stayed the execution of the award, because the very fact the award has not been fully executed, that itself shows that the money is still in the season of this honorable court. But I'll respond to what my learned friend is saying. Let him complete.
That is one correction on the facts, Millard. I'll just indicate the orders. First order. But I'll arrange my paper. I'll answer particularly on that, because Lordship has made a query there. I have to answer, or Mr. Bose, when he takes over, he will answer. I'll prepare the papers here. That is a question, pertinent question we'll have to answer, because I remember we had shown those orders sequentially and were also handed over to the court to argue this point. Today there is no attachment, yes. Where the receiver was directed, the interest portion, principal was paid, the interest portion which was there, receiver was directed not to disburse. The beneficiary under the award, no, principal was paid in total. The remaining part of the interest, that's the order of will show the orders once it order. I think Lordship would find the 30th July order. পরে অর্ডারটা দেখো, এটা না, এগুলো তুমি সিএসসি অর্ডার দেখাচ্ছ, এক্সিকিউশন অর্ডার গুলো।
Compilation of all the orders.
I think another compilation was filed by us.
Compilation, and that in the 30th July order is where they say page 12 of my compilation. The order actually, the first order on this point, if I can just assist the court, in and receive by it in bank account. So that was based on the decision of this honorable court.
12th August 2014. Lordship has seen the order.
Yeah, I'll just take to that order also. All these were continued.
Yes.
Yes. Still lying there.
That I've not seen him for many years now. I have to. I'll check. I'll check. When if the award subsists, it will go to the beneficiary of the award. It will, or if they succeed, they will come back to them. Either way.
If the 42 lakhs tax now this person is okay, then it's no problem. If we know where.
Government account. It will be a dormant account. to a dormant account, somebody has to, his legal heirs, they have to step in by filing requisite death certificate, and those documents are there. I do not know whether we are discussing all this without knowing whether. No, they will only, as a nominee, they may actually get that. They have to give a deed. And I don't think a receiver can have a nominee. I don't think so. Yes.
If we passed away, suppose he passed away, then he has to take himself, then has to be carried the interest.
That I think I'll take instruction on that. We'll take instruction on that.
Lordship, as far as I remember, Lordship, that he's no more.
That is what I have not seen him for many years actually.
Yes,
But it was under their application.
but I will finally check it out and I will. Yes,
The bank or the most normally just automatically keeps renewing it, but steps have to be taken to replace substitute's name by another receiver.
No, these are that was an application of them, not my application. So that prayer and those orders were passed under there, not my request. All these orders, yes.
If both, either you or he,
Yeah.
if anybody will get the benefit, then the amount has to be received by everybody.
If I will definitely inquire because yes, ma'am.
As on date. If it's no more, so how the account should operate?
That is a question that I also not have an answer ready. I have to think and come back with an answer with that. And
And this is vacating order 26.
kindly only one thing I'll show that kindly read the order dated 10th June 2014 with the order dated 26th June 2014. 10th June read with 26th June because now 10th June was the order of attachment 28 lakhs. Kindly see 20th June order, 6th June 2014 order. As a further order of execution, I appoint and such from the attached account of judgment debtor, Hong Kong Shanghai Banking Corporation Limited, is to prepare a draft pay order of the sum of rupees 28 lakhs. Pay receiver. Such draft payer has to be made ready by such and such. Thereafter, the attachment order will stand vacated. And so far as my instructions are concerned, the receiver, this part, 4th July till 4th July, there was complied. So the order of attachment was vacated. There was thereafter no further restoration of the order of attachment. At least they have not shown any such order. 10th July, yes. Yes. Yes, Milord. Milord. Yes, that's what I was submitting, Milord. The principal is no longer there. Yes.
Principal is, again, my learning is as per the order of 30th July, it is gone to escort with direction to retain its identity. So what my learning friend is getting that should be finally sold. It is finally very much under the season of this court because after on page of 20 by issuing a check in his account. Yes. Then on 15 July, there was an order say on the last line, after we entered a parent receiver to stay his hands for refraining to make over any sum or further sums collected by him. This is on page 6.
Yes, but by that time it was already handed over.
After that, yeah, this is on 15 July. And last line. Of also collected in person to. Then this was continued on 22nd July, and then comes the 30th July order saying retain identity.
In fact, the 12th August,
eventually
12th August, Lordship will find 12th August 2014 order. Mr. Mujumdar was directed to create a short-term fixed deposit. Yes, absolutely.
28th is already order of 30th July retained the identity.
That I have not.
That is on page 12.
What is the date of the order?
30th July.
30th July কি order আছে দেখো তো? পড়া খুঁজে পাচ্ছি না।
From missing. So this is what we are relying on. It's not complex. The process is not complete. Lying as it is there. They're supposed to identify. It is with the beneficiary, escort, and and they have been restrained. So that's the reason when the judgment, which I also in my learning also lying para 16, that the sale is not complete. It's not confirmed. It has to be the process. So this court is still seized with the matter.
No,
the property is not gone yet.
I was arguing that that was not in that case. The question was of sale. In our case, it's of an attachment. This court specifically recorded that the order of attachment is vacated.
Lordship,
The
the thing is that he is alive. He is not coming to the court.
He's alive.
That's what I was saying, that we are discussing all this without confirming about the the material point. Be that as it may, my argument was simply that this was a case of sale where the sale was found to be incomplete, and this was a case of attachment. The attachment order was specifically vacated by order dated 26 June 2014. The order is recorded there. The attachment order is vacated, and yes, and the money decree. Ultimately, the beneficiary was directed to not to touch the money and keep it in the bank account. But the execution is not complete. But the attachment, I am not on execution. The provision or the section. Yes. Yes.
Subsequently, then a serious point was raised before this court. This court found that yes, all the terms of that order that has been handed over, but the beneficiary has to be given, no, it has to be kept as it is.
But
Whether it's with the beneficiary,
yes.
with the receiver,
Good.
court has passed an order for vacating the attachment, but the amount is as it is.
Amount is that maybe it is bearing interest, more interest now. But I was only trying to establish that the question is not of completion of execution proceeding. With deepest of respect, the question is of completion of attachment. Now, there are two different things. In an execution proceeding, order of attachment has been passed. The money decree was attached. That attachment order has been vacated.
I'll catch up.
That attachment order has been vacated. The execution proceeding may not have come to its finality or may not be completed yet. But the provision of attachment has been fulfilled. That money, the order money which was attached, that order was vacated. The money is no longer attached. That is my submission. The escort is the under beneficiary of the award. It has asked. It was directed to retain the money in its own bank account. Yes, now if there can be contest in the execution proceeding. Once the contest gets over, he will get the money. It's a contest not between a third party. But that contest, there is a respondent in the arbitration proceeding. That respondent may come and oppose. But in execution proceeding, the respondent has a chance of defense. Section 47 could have been levied. So that may also be a scope of the matter. But may suppose takes over. So we are giving incomplete.
Yes.
Yeah.
The receiver, prepare the draft and to hand over.
Correct.
Thereafter, the attachment order will be stand vacated.
Right.
Correct.
Right.
First
Right.
paragraph, vacated.
Right.
Now, thereafter,
July. My lord.
10th July, receiver will immediately hand over transcription. So,
My lord.
immediately receive the check. So, escort award.
Man. Wait a minute. 30th July. My lord. My lord.
Like secondary, receiver
Yes.
And 30th July is the principal. This part. It is paragraph.
Yeah.
30th, my lord.
Correct.
Yes.
You enable this court to consider this application
Yes, ma'am.
In the presence of the parties, I direct the continuance of my earlier orders to the receiver with regard to disbursement of the fund. I also direct beneficiary of the award to retain any fund received by it from the receiver in his bank account. Correct.
Correct.
So, one order. At that time, there was no controversy. Court has directed the receiver to give the amount attachment back to it.
Right.
Now, this order is telling that
EPC.
no, there is here this application is to be heard. The receiver has entered over the amount to the beneficiary, the beneficiary is restrained from using that.
Correct.
The amount is to be paid in the sale.
Right. Right. So, my lord, now possibly what is passing through your lordship's mind is that this makes or this satisfies the test of Rule 58. Now, my lord, if your lordship looks at Rule 58, which has to be read in my respectful submission with Rule 55. Kindly see, my lord, the language used by the legislature. Where any claim is preferred to, comma, or any objection is made to the attachment of, comma, property attached in execution of decree on the ground that such property is not liable to such attachment, the court shall proceed to adjudicate upon the claim or objection in accordance with the provisions. Thereafter, my lord, proviso says, provided that no such claim or objection shall be entertained. But I need not trouble your lordship, we made extensive submissions on this. A, where before the claim is preferred or objection is made, comma, the property attached has already been sold. Or where the court considers that so now we are on A. Now, my lord, kindly read this with 55, Rule 55 once. Removal of attachment after satisfaction of decree, where the amount decreed with cost, well, this is relating to money decrees, and all charges and expenses resulting from the attachment of any property are paid into court, or satisfaction of the decree is otherwise made through the court or certified to the court. So the attachment will stand removed automatically. So our respectful submission is, my lord, the orders which your lordship has just considered, from here, my lord, two things are evident. A, that here the property is the money. It was lying in the bank account of the judgment debtor. So that property was attached. That property was taken out of the attachment of wherever it was in the bank account by the receiver. It was in the hand of the receiver. Now, if it is in the hand of the receiver, it is in the hand of the court. Now, it is given to me in pro tanto satisfaction of my decree. So the moment it comes to me, my decree is satisfied. Yes. No, if your lordship will see, yes, 30th July order says what? Correct. Yes.
I am fully agreeing with you with regard to the 26th July attachment order to stand vacated.
Correct.
No problem at all. So,
Right.
55 is satisfied.
Right. Right.
Now, then they entered 30th July.
Right.
I direct the beneficiary of the award to retain any fund. First, we have directed the receiver. I enable this to enable this court to consider its application in favor of the parties. I direct continuance of my earlier orders to the receiver with regard to disbursement of the funds in his hand.
Right.
I also direct the beneficiary of the award to retain any funds received by it from the receiver in its bank account or account.
Right.
So, only the amount would be retained in the account because it's the receiver given.
Right.
So it has gone to the beneficiary.
Correct.
And beneficiary has been directed to retain the said amount.
Correct.
Retention of the said amount
Right.
amounts to release of the attachment.
No, our respectful submission is that once because admittedly pursuant to previous order money has been come to me, but 30th July requires me to retain that. That means I cannot appropriate that. So the money that has come, I have to keep it until further orders of court. So me keeping it, me allowing me to keep it, in my respectful submission would not come within the purview of 58 or 55 read together. And then in any event, if your lordship sees the subsequent order, the foreign order, my lord, these orders, if your lordship will see on top, my lord, kindly see, these orders have been passed in the execution proceedings. If your lordship will see, the previous orders are all in execution proceeding. Then your lordship will see this order is in TA 130 of 2014 and 271 of 2014. In the suit. So even assuming, for the sake of argument, the contention of the applicant, if I even assume for the sake of argument, it is correct. So at best, that this retention by the beneficiary continued till the suit continued. No more than that. So the suit failed. In appeal, the entire plaint got rejected. So these orders are of no consequence, was of no benefit to him when he filed this objection on this application under Order 21, Rule 58. Have I been able to make myself clear? This order of 30th July is a complete departure from the previous orders passed in the execution proceedings. In their suit, in the interlocutory application which was moved, in those days TA number used to be unlisted. When we used to move it, urgent matters, we used to get a TA number. So my lord, in that TA which is in connection with the suit, there was an interim order directing us to retain the money. Interim order continued from time to time. Then when the rejection of plaint application came, suit was partly rejected. So the interim order went with the part rejection. Thereafter, full rejection happened in the appeal. So in any event, 2014 30th July order is of no benefit to the applicant when they filed this application, which was filed on 2020, subject to correction, my lord, 2020. 2020.
Sorry, 19
So this order, they cannot get the benefit of this order when they filed this application in 2020.
I'll respond to that tomorrow. This is actually incorrect. Many orders have been passed in suit again in execution. I'll talk about it tomorrow.
Suit rejected. So your interim orders ceased to exist on rejection. And you filed the application in 2020. Rejection was much before that. And full rejection was before the division bench. Between, even if we don't take part rejection, the full rejection, the division bench order. So thereafter you went to the Supreme Court and came back. So at that relevant point of time, there was this interim order was not in subsistence, and thereafter there has been no interim order. So till date, the 30th July order doesn't exist and did not exist when he filed the application.
I'll address that tomorrow, but I just want to know how long my learned friend will take, because this
I will not take. I have already confined my thing. So today I think we have to stop.
Because the court was pleased to fix 2 dates. My learned friend was about to conclude on the last date. I thought I'll start today. but the whole day has been taken. I wanted to know.
The difficulty is that, my lord, my learned friend has relied upon 30 judgments, 36 judgments. Now, if I start distinguishing, if your lordship gives me 2 minutes, that takes us 36 into 2 takes us to 72. Now, that's why what we've done, my lord, so that I don't have to face this from my learned friend, we have made a compilation saying how we have dealt with it, that how these cases are not applicable.
All I wanted assurance from my
that
learned friend that I'm starting tomorrow. I just want that assurance so that I can conclude tomorrow and then
Yes,
we'll
yes,
close.
certainly. I will not take by the clock. I will not take more than 15 minutes by the clock. By the clock.
But then
by the clock. By the clock.
3:50, because I would need also some time. Yeah, because my learned friend will says by 15 minutes.
I shouldn't give this kind of assurance. Then you'll hold me.
Obliged. 3 p.m. Deeply obliged.
3:45. 14 and 15.
May please, my lord. Heather.
Five, 508.
508. 508 exhibit list take to them. Now, this suit has come, Lord, for final hearing. Okay. The mark with objection. Lord, there has been, Lord, an error. Deposition to be. Lord, there are two suits, Lord, appearing together. One is Transfer versus Progredier, and one is Transfer versus, Lord, SM Containers. Both the witnesses were same, Lord, and both the documents were also same. What has happened, Lord, your Lordship may kindly remembers that there was a lease agreement which was Xerox, a copy of the agreement. My lord, in SM Containers, my lord, the other suit, my lord, it has been marked as marked with objection. But my lord, in this case, my lord, it hasn't been marked with objection. Only that agreement. Save and except that, my lord, every exhibit has been marked. So, my lord, your Lordship may kindly grant leave, my lord, that agreement may be. Lord, I'll try to prove it by way of secondary evidence because my lord, the reason why this document was marked, my lord, subject to objection, because there was no original. My witness has given a categorical answer in the deposition that the agreement was being executed only in one copy. It was signed and retained original. The defendant used to retain original, and a copy was shared to us. Then, Lord, accordingly, we had issued a notice to produce. That she has also referred in her deposition, Lord. So, Lord, by virtue of law, Lord, if I am unable to prove a document by way of primary evidence, I have to prove it by way of secondary evidence. That is, my Lord, my answer to the objection of the document. But, my Lord, that objection has to go into that document. This is what, my Lord, I am asking my Lord's leave. Then, my Lord, I shall proceed with the arguments. Your Lordship may kindly grant leave to mark that document, my Lord, with subject to objection. No, why during the course, my lord, it has been found out. That is why, my lord, I had pointed out. Yes, my lord, it couldn't be marked as an exhibit. It has to go with objection. I'm not asking my lord to exhibit it. I'm asking my lord to kindly allows the objection to be stamped, which is marked with objection, marked as X for identification. This is what. Yes, my lord. Then, my lord, I shall address my lord. Only if that goes, very well. আমার ওই হাতের লেখাগুলো কোথায় গেল যেটা এখনই পড়ছিলাম yes lord undefended suit my lord made ex parte by my lord Lord, I'm referring to CS 508. Earlier numbered as CS 101. Lord, agreement which is 1st of June 2018. It's not marked. Page 23 to 32 of the plaint. To 32 of the plaint. Or, my lord, if my lord is referring to the judge's brief, it's at page 3 to 12. Yes, my lord. This was the agreement, my lord. The witness has identified the signature. Witness has identified, my lord, the agreement. Only it has to be marked as X for identification. Yes, my lord. Deposition to बताइए लो. না serial number 1 থেকে কোথায় গেল? এটা তো 65. Yes, my lord. Kindly gives me a moment. Your lordship, may kindly see serial number, question number 18 onwards. Yes. This person has left, Mr. Mungekar. Otherwise, my lord, we would have brought him only. But since these kind of commercial documents, my lord, are being signed as in the representative capacities, your lordship may kindly see question number 23. This is the proof that I'll be referring to. The evidence as regards this proof is concerned. And Lord, as regards in case, my lord, when I don't have the primary evidence, I have to take recourse of section 65 of the Evidence Act to come out of the bar of the producing the original.
Where is the evidence that the Mangekar is not here?
Yes, my lord. In fact, I have an email also. I'll just show, my lord. My lord, may has this witness has not signed. My lord, may has the supplementary judge's brief. Kindly turns to page 80. Yes, my lord. 80, my lord, kindly sees the bottom, that email, Monday, 11th October 2021. This is Vishwanath Mungekar. This is that gentleman who has resigned, who had signed the agreement on behalf of the plaintiff. Yes, pay 80. Yes, my lord. The last email, which is 11th of October 2021, he states that from Vishwanath.
Also, secondary evidence, how you distribute either one of the witness to the agreement.
Signatory with yes.
Or witness to the agreement.
Yes, my lord.
Both. And if the Mangekar, where is the evidence that he left the office and is not? Where is your evidence? When he comes to the
Affidavit and evidence study. Yes, my lord.
employed was no, he is not available from office. He left the job.
As regards as that is concerned, I am not referring to the email at page 80, where he says that I am resigning from the company. Page 80 of the supplementary judge's brief. He says, as per yes, my lord, this has been collectively exhibited as, I'll tell my lord, that's PD 12. Page 80, my lord, may kindly sees. Yes.
kindly accept my resignation. My lord, at the bottom, kindly accept my resignation and relieve me at the earliest with my full and final settlement. Yes, my lord. Yes, my lord. This has been exhibited as Exhibit K, question 104. Into the second set of deposition. Collectively as Exhibit K. Lord, one. These are, my lord, emails, my lord, emails of the plaintiff's officials, which, my lord, this consists of emails, my lord, written to the defendant asking money. This is a trial mail. So the whole bunch was taken as a printout, and the defendant and the witness has said that this has been given from the team of the plaintiff. Page 80, my lord. Yes, 80. Yes, my lord. Page 80, my lord, the bottom email states that Mr. Vishwanath Mungekar is tendering his resignation and he is requesting to himself to be relieved. 80 of the supplementary judge's brief, my lord. Yes. And relieve me at the earliest. Yes. This is being sent by Mr. Vishwanath Mungekar. Your lordship, his full name is just above that. Vishwanath Mungekar. That email. So just to show that he has left. And my lord, may kindly, just to answer, my lord, the legal, my lord, objection subject to correction is section 65, my lord, C of the Evidence Act. Read with the answer at yes, my lord, read with the answer at 121 of the deposition, just to correlate that it has been called upon, they have not given. 65C says when the original has been destroyed or lost, or when the party offering evidence of its contents cannot for any reason not arising from his own default or neglect produce it in reasonable time. Yes, my lord. 65 subsection C. No. 65 subsection C. It says cases in which secondary evidence relating to documents may be given. Secondary evidence may be given of the existence, condition or contents of a document in the following cases. Now see, when the original has been destroyed or lost, that is not my case, or when the party offering evidence of its contents cannot, for any other reason not arising from his own default or neglect, produce it in reasonable time. So, my lord, read with the 121 answer at 121 when we have given notice to produce to the defendant, they have not replied. The notice, my lord, is referred at 121, the email. Yes, my lord. Your lordship may kindly refers 116 onwards. Your lordship will get the of my lord of the deposition 116. 116. Notice is not a part of the record because, my lord, notice, how can it be a part? The defendant is not appearing. It's an
Production of the document, how the 65 telling you are confusing which code? 65 C is to be proved by due diligence.
Yes.
One mayor coming the witness telling that he has gone to mainland.
No. Two parts I have to satisfy under to come under section 65B. One is that I don't have the original.
First of all, C is not the party to the agreement.
She is not the party to.
Witness to the agreement. She is not stated that this agreement was executed in her presence.
No. No.
Clear?
These three are not there.
Not there.
Not there.
Now,
What has she admitted?
question is here. I'm relying upon the Xerox copy of the document.
Yes, which was available with me.
Correct. And your case is that the origin is with the defendant.
Yes.
Correct. You are telling that you issued the notice to the defendant for production that has not been.
Yes.
The notice is not in record.
The notice is not in record. Not in record.
If the notice is not on record, so you being the party to the agreement has to prove that agreement.
Yes, my lord.
Secondary evidence.
Yes, no doubt.
Or secondary evidence to prove that either who's the party to the agreement come and identify the signature of both the parties. Here this is the agreement, original is with the other party, or original is lost. This is my signature, this is the other signature signed in our presence.
Yes.
Not there.
Yes.
Your case is that your party has also left the job.
The person who has signed has left this job. But what not. Yes.
She left the job.
Yes.
If she has left the job, she is telling that she knows the signature.
Yes. 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 Yes.
Officer capacity with signature appearing in the document, how is to be proved?
So, my lord, what happens in these kind of situations? If that person is not there, then, Lord, then the situation will be that this document will never be proved. So, my lord, what is the answer that I have, my lord, subject to correction by my lord, is that my witness has said that she is aware of the signature of this gentleman by the name Vishwanath Mungekar from the official records maintained by the plaintiff.
That is the thing. See, no, the signature of Mungekar. But with regard to this agreement signed by Mungekar in her presence.
No. She was not there in the service at that point of time.
Then, their signature identifying the document proof.
It will prove as regards as the existence, if not contents is concerned. It will prove as regards that signature is concerned and as regards the document is concerned. It may not prove the contents. Contents, my lord, is subject to, my lord, proof. What I wish to say, my lord, then, my lord, this situation will come to an outcome where, my lord, this document will never be able to be proved. So, my lord, the breakup, what I am trying, the breakup, my lord, which, yes.
You left that lacuna, you have taken your own plea, that notice was sent.
Yes, notice was sent.
The origin. The notice is not active. Whose lacuna?
Notice was, my lord, given. My lord, now just to tell, my lord, when we tried to exhibit that, your lordship had said that this is a Xerox copy, it cannot be exhibited. Then, my lord, next day, my lord, we became wiser, we took some advice. My lord, indirectly, we gave them the notice and then we came up with the. We have the printout. That notice, my lord, has not been exhibited.
If the notice is not executed, okay, leave aside the notice is not executed. You have not filed any application directing the defendant to produce the document through the court. Or you have not sent the notice to the defendant.
We have sent a notice. Order that is not exhibited, but we have sent a notice.
How the oral agreement can be relied to can be taken into consideration relying the secondary evidence.
My lord, oral agreement, I'm sorry, my lord, I missed.
Yes.
Oh, oral evidence, yes.
Can be relied.
So, my lord, that is why, my lord, I just tried to become wiser. My lord, I introduced these.
When you are evidence, my mind was distracted. I have given the point, but you are not.
Lord, I introduced these questions. Kindly see.
Not covered that.
Kindly seize, my lord, 115 onwards, just to satisfy, just to, my lord, save myself or to satisfy my conscience. Kindly seize 115. Question number 115 of my witness. On the last occasion, you had submitted that a copy of the agreement and such was kept by the plaintiff in its record. Are you in a position to tell before this court from where did the plaintiff obtain a copy of the container lease agreement?
She says it is the Xerox copy of the original. Mr. Vishwanath, who had signed on behalf of the company, Xerox the document had kept in his possession and the same has been maintained in our record. So next, has the plaintiff initiated any step in procuring the original of this document being PD3? Yes, on advice of my advocate, I have instructed her to send a notice to the defendant to produce the original before this court. Then shown a document, that was that email. Is this the email you're referring to? Yes. Then this is the date. And then what was called upon? The agreement was called upon to be produced. So, my lord, to be safe, I had introduced these questions in the deposition, my lord. I had asked the witness these questions. She has given these answers. Email is, my lord, we can hand over a copy. It's not exhibited. Lord, I don't know. That is a legal question, Lord, whether these kind of communications are to be exhibited or not. Inter-party communications after the trial has begun, or rather during the EA. Lord, I think that if under order 11, my lord, if one doesn't produce, my lord, a document, then the court, my lord, can take adverse inference as regards as non-production is concerned. As regards as non-production is concerned. So, my lord, I think if my lord is of the view that I have to file an application, I can file an application. But so far, my lord, to come out of that legal bar, my lord, I have taken. No, my lord, I am saying that to come out of the legal argument, my lord, I had introduced these questions so that, my lord, these can be taken care of. Your Lordship may kindly seize the notice. Kindly seize, my lord. I am not asking my lord to refer and rely on it. Kindly seize it once. So, my lord, I tried to comply with the legal part, my lord. Now, my lord, only this is the objectionable document which is there in the record. Other than that, my lord, all the documents have been marked as exhibit, my lord, without any objections. So, he could an application code to produce. I haven't started on the merits. I haven't started on the merits, Lord. I'm just taking instructions whether file code. File code. Lord, may kindly, Lord. Lord, I shall file that application. If my Lord is not satisfied with 115 onwards, then I'll have to take the. Yes, yes, after the trial. My lord, the moment when my lord took this objection. Yes, the my lord, yes.
You have to take the legal record. If it is on notice, but during the inspection, the plaintiff or the doctor, dependent is not producing the document.
Yes.
So what you will say? You will say yes, the inspection completed.
That is a case where defendant appears. In this case, defendant is itself. Yes.
So what you will say? Inspection completed, you will immediately report to the court.
Yes, my lord. And I'll seek an order of production. So, my lord, on the oral prayer, on the basis of this notice, my lord, I'll be seeking an order of production. Secondly, my lord, kindly visualizes a situation, my lord, where the attending witness of a will dies. Then, my lord, how to prove that will? The person will come and identify whoever is aware of the signature. That yes, this is the signature of Mr. X. Yes.
She is not the attending witness. She was not in the office.
She is not the attending, attesting, neither she is the executant of that document. But what she is aware of the signature. Yes.
Signature is appearing, mind you. Signature, if the signature is executed also, how you can say the contents is she know the content?
Contents, my lord, it's not, my lord, it is not a will, my lord, it's a commercial document. A person.
From the basis of
Contents, yes. Yes.
You will supply the container.
Yes.
They will give the
Lease rental charges. Yes. Part payments made, some unpaid. Yes.
You have made the request.
Yes, my lord. Yes.
So
The contents has to prove this is the paragraph wherein the agreement has entered with the C party. It has to give this is the amount fixed.
That she has given in her affidavit because that was done by way of chief.
So, complete. Save it.
No, no, my lord, I have to answer, my lord, on these points. My lord, I will, your lordship, my lord may kindly, my lord, on the basis of that email, my lord may kindly order, my lord, a production, my lord. Otherwise, I'll have to file an application, my lord. My lord, this notice to produce, my lord, is the legal compliance. My lord, that is why, my lord, I am seeing on the verbal, my lord, on the oral prayer, my lord, I am saying, my lord, because I have already issued, I have given the questions also. Very well. The CPC ko to gelo amar. Your lordship, as regards order 11 is concerned, my lord. Order 11, rule 14. Twelve asks me to file an application, and 14, my lord, is the power of the court. In June. Your lordship may kindly, my lord, any date after 19 any date after 19 June. 24th. And my lord, also the next fixed matter. See. Both, my lord. Both have this same point only, this Xerox copy. Extremely grateful.